Welcome, 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 one and all, to yet another episode of WhickTV, the cross-ideological space where we come together to talk about issues both political and cultural, from the silly to the serious. Gang, we're waiting on a couple of guests right now. They're here. They just got caught up arguing on Destiny's stream about this very topic, so we're trying to wrangle them back and get them back where they agreed to come. But I wanted to say happy holidays to everyone. I hope your Christmas, if you celebrated, was great, or your Hanukkah or whatever it is that you celebrated was awesome. Thanks for being here, and we got a show for you today. How's everyone here doing? Are you guys being good?
Oh yeah. Oh great.
Yeah, it's been a good holiday.
Yeah? What did you do? Anything fun?
Yeah, what did you guys do? We just moved, and so we had a big Skype call with my parents.
A Skype call.
Mm-hmm.
Yep. Had holidays with girlfriend's parents this year because mine are both out of state as well. So
Fair enough. Fair enough. Josiah, hi. We got
What up,
one of the teams are here.
Yeah. I told. Peace goes backstage now.
Peace goes backstage. Yeah.
Okay, we got him. We got him, gang.
Sorry about that, folks.
It's fine. It's fine. Take your time. Take your time. We're live, by the way.
Got it. I'm getting my setup. So just start with I'm hearing all of you, but I'm ready to go. In terms of
Okay, that's cool. And with that, let's discuss the topic that we're going to be talking about tonight, which is the recent Colorado State Supreme Court decision to remove Trump from the ballot. This just today, a few hours ago, the Colorado Secretary of State made it clear that if the Supreme Court does not uphold the decision, if it's still in limbo, if it hasn't been ruled on, that they will keep him on the ballot, right? But I still think it is worth discussing whether or not the Supreme Court of Colorado was upholding the law, or if this was some sort of dirty pool played by the Democrats to get their nemesis taken off the ballot. I want to talk about this not only from a legal perspective, but also from a moral perspective as well. Is it right to deny someone the ability to run for office in this country? I don't know. We'll talk about it. But first, I want to give each of these lovely guests an introduction, give your opening statements, and we'll see where we go with it. And we're going to start. Longtime friend of the show, hasn't been on in a while, 𝕵𝖎𝖎. Hi.
how's it going? I'm 𝕵𝖎𝖎. I'm a conservative person who argues on panels sometimes, and I think that the Colorado Supreme Court is right in their decision. I agree with their statement that the 14th Amendment is relevant, that it applies to presidents. My only question is Donald Trump's specific engagement in insurrection, and as long as the Supreme Court ruling clarifies the process for determining that, I'm completely satisfied with Donald Trump being removed from the ballot. I think the argument that the 14th Amendment doesn't apply to presidents both doesn't pass the language test when you read the 14th Amendment, and it also just doesn't pass the logic test, in my opinion, that they would be banned from every office except for the one that can, pardon all the others. So that's my opening.
Well, thanks for being here, and I'm sure we'll get into it as we go. Next up, we have another longtime friend of the show. Haven't had her on in a while. Johnny Scarlett, go ahead.
Hey, friends. Hi, I'm Johnny. If you've never seen me before, I'm an educational streamer, and my primary focus is in philosophy, but we also talk about politics as well occasionally on the stream. We had a pretty good discussion about it earlier today on a live stream, and right now, as it stands, my initial thoughts are that this is not something that I saw Donald Trump explicitly state, that violence should be committed in his January 6th speech. I also looked at his tweets from around that time. All of those are, of course, recorded by the United States government. And I didn't see anything that explicitly called for violence, but I know that the other argument for this is that his attempts to make states overturn elections or find more votes for elections could also be considered insurrection or rebellion. I'm interested to hear people's arguments on that. And we'll see where it goes, friends.
We will see where it goes. Thanks for being here, and we appreciate you coming in with open mind. Speaking of open minds and being great to have here, Josiah, Pondering Politics. Hi.
Hey, everybody. So I'm Josiah. I have a progressive politics channel on YouTube called Pondering Politics. 𝕾𝖍𝖎𝖙 and I are best friends. It may not seem like it as a result of this conversation, but I assure you it's there. As far as the case against Donald Trump, as far as I'm concerned, it's a slam dunk. The Constitution, limits who you can vote for in the first place. You don't get free reign. You can't vote for somebody for president who's not 34 and a natural-born citizen. This is another qualification. You can't have previously taken an oath to support the Constitution, then betray that oath and be allowed back into public office. So this is yet another constitutional parameter against Donald Trump. I think it applies both to respect to his actions and inaction on January 6th, and in his actions leading up to it, with respect to trying to steal the election from Joe Biden, the rightful winner. So as far as I'm concerned, I think the Colorado decision is correct. There are probably going to be enormous political and social consequences to it. But if we are a nation of laws, then we have to follow this one no matter how uncomfortable it gets.
Well, thank you for being here, and we'll see how it goes as we get into it. Next up, our friend, my personal friend, 𝕾𝖍𝖎𝖙. Go ahead.
All right, I warned Wick ahead of time. This might be a little bit longer, but please bear with me. So, although the Supreme Court does use an originalist flavor for this decision and make one of the more compelling opinions than what I'm used to seeing from that particular legal philosophy, I do believe the Colorado Supreme Court is still wrong for a number of reasons. Firstly, I'm not convinced plaintiffs have jurisdiction. This has been decided in similar cases in the past and is the opinion, standing, and is the opinion of the vast majority of state courts that have substantially similar election statutes and have heard these cases on Trump's disqualification. Secondly, Donald Trump has not convincingly been shown to have committed insurrection. The portion of Judge Wallace's opinion and the Colorado Supreme Court's opinion establishing that he did commit insurrection reeks of TDS. It minimizes the statements he made to remain peaceful and to leave, and emphasizes statements such as fight like hell, which in a political context can obviously mean something peaceful. Thirdly, the 14th Amendment, especially if used as a sword, is not self-executing, as established in Griffin's case in 1869, praised by Ex parte Ward in 1899, and further emphasized by one of the drafters of the 14th Amendment, Thaddeus Stevens, who expressly stated that Article 3 of the 14th Amendment was not self-executing. Fourthly, even if Trump did commit insurrection, Article 3 of the 14th Amendment does not allow for the disqualification of Trump as admitted by Judge Wallace, because Trump is not an officer of the United States, under the United States, as used in Article 3 of the 14th Amendment. This is backed up by no less than 3 Supreme Court cases: Free Enterprise Fund versus Public Company, U.S. versus Moat, and U.S. versus Germain, all defining officers as separate from the executive. And it is also backed up by basic statutory interpretation and consistency within the Constitution. And it is also backed up considering that a prior draft of the 14th Amendment, specifically Article 3, had the president and vice president included, and then was revised to remove them intentionally for the final draft. Finally, as the New Hampshire court decided, this is under the political questions doctrine. In a prior case, Grinnell's versus Electoral College, a case that was brought against Obama, alleging that he was unfit to be on the ballot by alleging he was not born in America, the court did not remove Obama. Imagine the insanity of a judge heeding some political hack, giving questionable testimony, claimed that he had found that Obama was not actually born here and everything was a forgery, and removed him from the ballot of a state. What if a judge finds the same thing about Biden? The idea that a Reconstruction Amendment, remember, just after the Civil War, would allow a state court to bar a presidential candidate without congressional approval just runs afoul of both history and the Supremacy Clause.
Well, thanks for that, and I'm sure we'll get into it as we go. Next up, we have quibbles over coffee. Go ahead.
So I want to build off of basically everything that 𝕾𝖍𝖎𝖙 just said, just more from the moral perspective than the legal perspective. When we're thinking about the impact of elections are only as legitimate as the people understand them to be. And when we're talking about lowercase d democracy, which is, I think, that hopefully something that we all support, that is only going to function if everyone can have that undergirding trust. And when we have things like this, a 4-3 decision that is being made by judges of a state court, and that is going to have this massive impact on the decisions that we're able to make as people in Colorado and more broadly as Americans. The impact of that, I think, is really dangerous, and I think that it's really important for us to be concerned about the downstream consequences there. This is the kind of thing that happens in third world countries. This is the kind of thing that happens in places that don't have a tradition of democracy. And that tradition of democracy is more important to defend than the simple questions of the everyday politics. And I think that, if you care about institutions at all, which I certainly do, the institutional defense here has to be very, very cautious, and certainly to have all of these things really be Loctite as a legal argument. And it should not be a 4-3 decision. It should not be a 5-2 decision. It should be a 7-0 decision, number one. And number two, it should also be something that is understood, and they should have already gone to jail and all of those things if this is even going to be on the table as a consideration.
Okay, thank you for that, and I'm sure we'll get into it as we go. Last, but certainly not least, first-time guest on my show, but we've been on different shows before together. Pisco, please.
Yeah, thank you. Listen, so happy to be on the show. Wick, thank you for hosting this panel on this issue. I think it's a super duper important issue, and obviously people have strong feelings about it, but the current sort of state of what's going on, nothing has changed substantially. If you guys have sort of seen the Secretary of State coming out and saying that they're going to not remove Trump from the ballot, they're just enforcing the existing Colorado Supreme Court order. So it's still very topical despite what the Secretary of State said, and I think will ultimately be determined by the Supreme Court on the law. I think a lot of the points that people have raised so far are really great and get to the heart of like this issue. And I'm happy that people are concerned about this in like a political philosophy or prudential sense. And I heard Quibbles sort of speaking to that issue because it is something that matters in terms of ethics and our thoughts and our feelings about who we are and what our democracy represents. But if there's one thing that I'm going to kind of advocate for here, it's going to be that those concerns should not be predominating our conversation. Why? Because the most important thing that we can do right in this entire situation is following the Constitution. It very well could be that the Constitution leads to some bad results, that the Constitution leads people, applying the Constitution leads people to distrust the political process. That could be the outcome, and that has been the outcome for many years in a lot of controversial decisions. Brown v. Board, Roe v. Wade initially, the overturning of Roe v. Wade. There are a lot of cases that stretch both the political discourse and the people's faith in our systems. But the bedrock foundation of this country is the Constitution, and so applying the Constitution is not discretionary; it's mandatory. And so whatever those prudential concerns are, should it be 5-4? Should it be 7-0? Is this fair? Is this not fair? All those those concerns are really important to talk about in terms of what to expect and about what our feelings about whether we should overturn this amendment and what do we think about the amendment. But they're not applicable to what we should do next. What we should do next is the same thing we do with the Second Amendment, same thing we do with the First Amendment, and all the other parts of the Constitution is enforce what the Constitution says, period. And so I think that lactoid's opening is what we need to talk about. This is a strictly legal question. I think Lactoid would actually agree with this, that if Lactoid was convinced by the legal arguments, that would predominate over any prudential concern. Lactoid would say, just like the Second Amendment might be inconvenient for certain people, or, the right to be free from certain intrusions by the state might be inconvenient, you have to apply it. And part of the system means applying the Constitution. And so I'm happy to address during the open panel the kind of threshold questions that Lactoid's bringing up. Does it apply to the president? Was there insufficient due process? All that stuff. And then merits of the insurrection claim and the First Amendment stuff. But one thing I really want to strongly advocate and be heard on is that the most important thing is what the Constitution says. And we should follow that even if it is uncomfortable.
Okay. Well, with that, let's open it up, gang. If you have troubles getting in, just raise your hand, or if you're on a cam and can't raise your hand, just send me a DM or something, and I'll try to get you in.
Sure, I'm trying to get that up and running. I'm sorry.
All good. I guess we'll start off by reading a super chat from Artemis Fowl to kind of kick this off. I want you to follow the Constitution. This is from for $10. I want you to follow the Constitution when it serves my needs. Also, the previous draft's current wording and intent of the 14th Amendment author should be ignored. And that is a question, right? So 𝕵𝖎𝖎 in his opening statement talked about how we should follow the Constitution even if it's uncomfortable. Do we agree with that? Is there anyone who would disagree with that statement?
So what's actually funny is I am more open to the utilitarian argument that following, like, to me, the law question is relatively settled and straightforward from the law reviews I've read and the commentary from Lawrence Tribe and Ludig and 𝕵𝖎𝖎 and others. To me, if somebody says, listen, the Constitution is clear, Donald Trump did engage in insurrection, he should be disqualified because, of course, we wouldn't make an exception for the most powerful and dangerous office in the fucking country. Anyone who suggests otherwise is a moron. Setting that aside, but it would cause extraordinary civil unrest if we were to follow this to its natural conclusion. I am actually more sympathetic to that argument than the idea that the presidency doesn't apply. So if somebody wants to make the case, listen, we've got Trump dead to rights, it's a bad faith argument to suggest otherwise. I just think it would destroy the country if we followed it. On a personal level, I'm open to that argument. I think that you would be tacitly conceding that we're not a nation of laws and that Donald Trump in this situation would be above the law as a result from that. I think that that's what you'd have to concede to.
I guess I would agree with that if it's a nuclear holocaust coming up. But absent that, we're in dangerous territory. If we're picking and choosing when to apply the Constitution based on like our intuitions about what the consequences will be, I think that's dangerous territory. And just to really
just to clarify real quick, I agree with you. It's dangerous territory. I'm not saying that I agree with that. I'm just saying I'm open to that argument.
I mean,
you're not conceding on the outcomes. Yeah.
For me, one of the frustrations too, as a conservative, someone who voted for Trump, and to be clear in this conversation, if Trump was the Republican up against Biden in the next election, I'd vote for him again. For me, this is a legal issue because I agree with 𝕵𝖎𝖎, the law is the only thing that should matter, because I think that as conservatives, it's massively hypocritical to do it's immoral, it's undemocratic. Yeah.
Jeb, I'm sorry, could you repeat that again for 𝕬𝖏𝑗 there? It's massively what?
I would say it's massively hypocritical to argue that even if I don't think 𝕬𝖏𝑗 agrees that the Constitution says that Donald Trump needs to be removed. I'm saying if 𝕬𝖏𝑗 were to make the argument that even if it does say it's undemocratic, so we shouldn't do it, that's a bad argument. And I heard Trump himself say it's undemocratic and all this stuff. Yeah, no shit. The Constitution is definitionally undemocratic. And conservatives, we've been the ones spouting to people for the past 10 years, we don't live in a democracy. We live in a constitutional republic, and the purpose of the Constitution is to provide a framework and limitations for democracy. Everything in the Bill of Rights says Congress shall not pass a law restricting blank, which is fundamentally saying we are not allowing a democratic process to overrule these rights. And I think that if the Constitution says that Donald Trump needs to be removed, even as someone who would vote for him over Joe Biden, he needs to be removed because for all of those same conservatives, if we found out tomorrow the Democrats did collude against Donald Trump, they did cheat, they would want every single one of the Democrats that was proved to be involved to never be able to be president ever again, to never be able to run for president ever again. And the only way they could get that outcome is by us upholding here right now that Donald Trump needs to be removed from the ballot.
So I think that the problem is this.
$100 from Lex Friedman to say happy holidays. Happy holidays to you too, sir. Thank you again. Go ahead, Quibbles.
Wait, the Lex Friedman or a fake account?
No, it's the real one.
They're buddies.
Sweet. That's awesome.
Lex hangs out here, yeah.
I think the problem that I think about in this context is institutions are as strong as people's trust in them. And when we talk about, like, a lot of people have talked about, the last election having been stolen, for example. And I don't think it was stolen, but I do think that it's a conversation worth having, not because it's true, but because it's something that is believed by a large proportion of the society. And I think that when people have that belief, it's something that we have an obligation as people who believe in the institution to talk about and to grapple with that as a belief. And I think that similarly, if there's this belief, it's something that has to be grappled with as a belief that this is something that is unconstitutional. And I also think, to be clear in this particular case, that it is unconstitutional, that the finding here was unconstitutional. But even if it weren't, it would still be something that I think is worth discussing and worth thinking about and grappling with beyond that.
Quibbles, I
think we
totally
all
agree
agree
with
with
that,
that. Yeah.
but like just to be 100% clear, I agree with what you're saying, and I more than anyone was involved in the discussions about allegations of voter fraud, because I think it's really, really important to have those discussions, as you say, when there's a lot of people who have that belief. My only position is the legal question resolves what we should do, right? Like, you would never advocate, hey, if the Constitution mandates that Trump is disqualified, we shouldn't follow it, even though it says it, right?
No, I don't. I don't think that. But what I do think is that if that is something that is understood by a large proportion of society, that there would be an obligation to be exceedingly careful about it, and that as is happening currently, that it would have to go to the Supreme Court, number one. But number two, that it would be something that I think that the correct decision is to wait, for example, for him to have been sent to jail, for example, and we would have to wait, for example, for more evidence and for it to be more overwhelmingly clear before we leap at decisions like this prematurely.
But the argument
that was
the other
Lactoid's argument, wasn't it? That this is not, Section 3 is not something that is self-imposing. There would need to be some sort of case that was definitively decided against Trump. My question is, and unfortunately I didn't get to research this personally, but I was sent a message right before we started that essentially said that Colorado had gone through a sort of state process to establish Trump's insurrection before he was actually determined by the Supreme Court to be ineligible.
They had a 7-day trial at the district court level. Trump's attorneys were there. They brought in witnesses. They cross-examined the plaintiff's witnesses. And if you actually read the Judge Wallace's decision and the appeal and the Supreme Court, the Colorado Supreme Court decision, they just didn't make that good of a case. As a matter of fact, it's hilarious. The one witness, the one constitutional scholar that was on Trump's side actually conceded multiple arguments to the plaintiff's constitutional scholars. So he had due process in terms of a 7-day trial, and then the Colorado Supreme Court reviewed it. But what I was going to ask Quibbles was, you mentioned something about jail. That the idea that the Section 3 of the 14th Amendment, we shouldn't apply it to Trump in the event that, unless he's convicted. But what if, and 𝕵𝖎𝖎 and 𝕍𝖎 can probably get into the language much better than I can because they're trained attorneys, but what if the language doesn't require a conviction? It doesn't say anything.
I can read it to you. It does. It says I can read it to you. This is from Section 3 of the 14th Amendment. It says and it explains, to support the Constitution of the United States, if they shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof.
But that doesn't mention a charge. Right? That doesn't mention a charge or a conviction.
That's not a criminal
insurrection or rebellion against the same, against the Constitution of the United States.
But it doesn't specify that they need to be convicted in a court of law. It is something that could put you in jail. It's something that could.
Hold on. Yes. No. Hold on. You are innocent until proven guilty in the United States of America. Right?
No, because you can impeach and remove. Hold on. You can impeach and remove a president without a criminal conviction.
In order for someone to be guilty of having engaged in insurrection or rebellion against the same, against the Constitution of the United States, that is a crime.
No, it's not.
So you must be convicted.
No, not necessarily.
I want to pass the mic to 𝕵𝖎𝖎 for a little and to explain why, because that is a question, right? He hasn't been convicted. He hasn't.
I'd like to respond to some stuff after that.
And I'm happy for Lacto to take the torch after this. I think it's a good question because the intuition when you hear the words insurrection or rebellion, it very much sounds in criminality. It sounds like it's accusatory at the very least. So I don't fault people for thinking that there's criminality implied there because the language very much smacks of that. But you have to be aware that the Constitution is not a criminal code. And a lot of provisions that sound accusatory, for instance, 𝕍𝖎𝖏 brought up the impeachment clause, the high crimes and misdemeanors. The word crime is there, right? It says high crime or misdemeanor. It says, there's specific references also to bribery and to other the definition of treason. None of these, but we know, of course, that the impeachment clause is not for criminal prosecutions. The impeachment clause are for political prosecutions, you could say, or political procedures. And so in this specific case, right, we're not talking about a remedy where criminal sanction is the result of it. The sanction at the end of this proceeding is disqualification. And I think, based on the historical practice of the application of Section 3, we should not read in, and also the plain text of the language, we should not read in criminal level procedures or that this is a crime unless it's specifically called out as such.
It says having engaged in insurrection or rebellion, which is against 18 USC 2383, right? I
When
just
was
sent this into
18
the-
USC
That
codified?
was
I'm
passed
pretty sure it was in the
after, but,
40s.
This
Yeah.
was codified, yeah, sure.
Right,
So if
but
it's against the law,
well, wait a minute. But Section 3 of the 14th Amendment was ratified in 1868. So this happened nearly 100 years later, where the crime of
right, but if it's
insurrection was
against the
codified.
law,
Yeah,
if
Wait
for
a
it
minute.
Congress
is
to get
against
rid of
the
that
law,
law,
Okay.
Congress could strike
whether
down
it
the
was,
insurrection.
hold up, Pisco, hold up. If that's against the law, right, which it is against the law, to be engaged in insurrection or rebellion against the Constitution, then surely you need to be guilty of having broken that law before you can be.
No, Quibbles. So in the context, let's show another context where we've seen it executed a few more times. In the impeachment process, right? Misdemeanors and high crimes are specifically entailed in the impeachment process. You don't have to be found guilty in a criminal court of a misdemeanor or a high crime in order to be impeached. You just need the House and the Senate to agree at a vast majority that you need to be both impeached and removed from office. None of it requires any criminal case. It's not even a question. It might support the idea that you committed those things if it is available. It's a convenience for sure on the side of the people who want someone impeached or removed from office, but it's not a requirement. Since the text doesn't require a criminal conviction in the text, it does not require, you don't have to be proven in a criminal court to have done these things. That's why I said all I would require from the federal Supreme Court is a clarification for what process we are going to use in order to confirm that Donald Trump had committed it.
I have a yes or no question for Pisco, and
Sure, and after that, and after Pisco answers the yes or no, I do have to pass the torch to Lactoid because he can probably explain a little bit.
Yes, it's a question for Lactoid as well, actually. I would like to know both of your answers. My question is essentially, this was built on keeping Civil War generals and people who engaged in the Civil War from running for office in the newly reunited Union, correct? And so it was not required that every single one of those Civil War advocates or generals or whatever be individually convicted to be mass excluded from running for office within the Union, correct?
Yeah. So that's correct. What you're saying is that this was designed with those people in mind, but of course they used general language, right? If they just wanted to disqualify those particular individuals, they would have just said anyone who participated in this Civil War that just happened, right? But the fact is, they used the general language that applies to different cases because it's a constitutional provision, not like some specific bill of attainder. And so in this case, like why should we assume that formal procedures were not necessary, or sorry, it was okay in the context of the Civil War to just like summarily do it, but it's not okay in the context of other insurrections that could occur. The procedures should be the same under either context. That's my argument, because the specific language does not specify heightened scrutiny for non-Civil War situations.
But Johnny brought up a good point there where she just said that when it was ratified, that the Confederates to whom it immediately applied were not tried or convicted of anything. It was an automatic disqualification that applied to hundreds or thousands of Confederates. So to Quibble's point, when it was applied, it was understood we're not going to try and convict Confederates of insurrection. It's just you engaged in insurrection, that's it. You're disqualified from office.
Okay, Lactoid, go ahead. You're raring to go, I can tell.
All right. Yeah, I got some points. I'm struggling with a little bit of stuff right now, so I apologize. I'm not going to be as aggro as I would like to be. But a while ago, Josiah said that anybody asserting that Article 3 doesn't apply to the president is a moron, and that it's common sense that it obviously does. I think the inflammatory language and appeal to common sense here betrays weakness. It's not moronic to believe this, and multiple scholars don't agree that this is the case. I don't disagree that it is somewhat ambiguous, and there is a discussion to be had, but there is absolutely a reasonable position that Article 3 does not apply to the president.
Could you articulate it?
Yeah, I'll get into that in a second. Okay. I do have points down, though. So I guess and this is a question to Pisco that I actually would like to have answered. So Pisco, you kind of started out your intro by saying, this sort of, forgive me, uncharacteristic admiration to the Constitution and wanting to stick to it, and even bad cases. I think you pointed out Brown versus Board and Roe versus Wade. That in reality, even if these lead to political outcomes that we dislike, we have to stick with the Constitution. But if I'm not mistaken, Pisco, we've literally debated Roe v. Wade before, and you brought up kind of in a sort of incendiary manner, like, what about the political ramifications of Brown versus Board? What about the political ramifications of Roe versus Wade? So I guess do you at least understand why perhaps it is kind of a little bit odd to me how on those, it's perfectly fine, at least in our discussion, to be concerned about the political ramification. But then here, when it comes to Trump being removed from the ballot, you have a very, I guess, consistent originalist perspective. Why is that?
Well, I'm happy to answer that. And I think that someone could observe that perspective where, like, how come he's in favor of taking into consideration the real life consequences of one decision, but not for the other? And the reason is part of the legal analysis of stare decisis includes settled expectations. And so the determination for when to overturn and not overturn a case prices in expectations, and specifically calls on courts to consider the consequences in the real world. And so part of the legal analysis of when to overturn a settled decision, which no one can deny, Roe v. Wade was affirmed multiple times, involves the court running a stare decisis analysis. And the stare decisis analysis prices in the consequences to society. Now, at the first initial step, right, Roe v. Wade should not be decided based on intuitions of consequences on how it's going to be received in the general public. But as a matter of stare decisis analysis, I think you would agree, at least as has been expounded on by the Supreme Court, practical expectations of people, the settled expectations, and those kind of things are one of the most important factors to look to when overturning. And in Alito's opinion, he is arguing that there is no settled expectation because no one agrees.
So I don't disagree that stare decisis is a factor. Obviously, with the Supreme Court, who can overturn the Supreme Court, I don't think it's a definitive, established, we can't ever undo this. But I'm curious, Pisco, does that mean that at the time of the ruling of Brown versus Board or Roe versus Wade, without the supporting case law that came after, you would have not been in favor of those cases? Is that true?
No, I would have been in favor of Brown versus Board and overturning Plessy, because the analysis on overturning Plessy absolutely, in terms of the consequences, showed that our experience, that separation by itself, separate but equal, did not actually produce those results, and that there was this enormous conflagration in the South of strife and civil discord that were not at all, right, like the kind of settled expectations that one would expect when analyzing stare decisis. So in the situation of Brown v. Board, I would give less weight to Plessy because of the circumstances of the turn of the 20th century and the enormous problems of race relations that occurred. And so me being okay with citing the real world consequences in the context of stare decisis analysis is just me pointing to the legal framework for that doctrine and applying it. Now, you might disagree on my application of it, but it's totally appropriate to consider the real world effects when undergoing a stare decisis analysis. And I think I'm consistent.
And then you would oppose Roe v. Wade, though, at its like the initial Roe v. Wade decision. You would have opposed
I wouldn't
that.
oppose Roe v. Wade because that was a decision, that was an issue of first impression by the Supreme Court, as I understand it. And in that situation, I agree with Roe v. Wade. I don't want to turn this into a Roe v. Wade
Yeah, I was about
debate. But just to be clear, like, there's nothing inconsistent about me not taking into account. In fact, it is extremely consistent. If I'm saying right now, don't take into account public pressure on the decision in this context, it would be consistent with me saying in Roe v. Wade, don't take into account public pressure there. The one place where you're supposed to take in like public expectations and all that stuff is for stare decisis analysis. That's how I understood the framework.
I don't disagree. So, and I'll just talk, I suppose. The reason why I ask, when Roe v. Wade was first decided is I'm not talking about stare decisis, the cases that came after that affirmed it. I'm talking specifically about this sort of novel, like you said, first impression interpretation of the 14th Amendment applied to abortion, which there is no originalist basis for. And it just seems odd to me that, you would defend it then when there's no originalist basis. But then
I'm not an originalist. I'm not hiding the ball. I'm not an originalist.
Okay, so you think that, okay, so you'd say that we should follow the Constitution, and the Constitution happens to allow the 14th Amendment to protect abortion, but it doesn't allow the 14th Amendment to, or it requires that the 14th Amendment allow a district court to remove a presidential name off a ballot.
Yeah, what about that is inconsistent?
Well, as we think about what's inconsistent, there is a question from Lex Friedman for $20. If Trump is removed from the ballot, do you think it could drastically worsen the division of an already divided nation and thus do more damage to democracy than any one leader can? So
I think we already answered that kind of like, and the
would-
answer is it's sort of irrelevant. I mean, it could or it couldn't.
Wait, hold up.
Josiah could
I'd
make-
like to jump into that, though.
That's not a fair question. That's not a fair answer there. You have to be
Sure.
able to answer it yes or no. And you can also say whether or not you think that it's a relevant question. You can take issue with it, but you also should.
Sure. So we can answer it. And so
right?
I agree with Josiah that not following the Constitution, even when it's unpopular to do so, sets a horrible precedent and could do nothing other than inflame tensions. Is it going to be more or less than the tensions of the act itself of disqualification? I can't possibly predict that. And anyone who knows or guarantees that they know exactly what the actual outcome will be, I think they're lying to you, because maybe disqualifying Trump and keeping him out of the question, and let's say that you nominate Ron DeSantis or Nikki Haley, maybe that actually helps things, because maybe you don't have Trump as a polarizing figure. I don't know, and you don't know either. And any kind of what's the word? I'm not.
I'll go after John.
prognostication.
This feels like a level
exactly.
of
On that are based on Fields' arguments, in my opinion.
that feels like a level of like meta ethic, like, ooh, you don't actually know anything, kind of.
It's not like that. No, I think this is
confident.
I don't think it's like that, because
confident
it's not like predicting. It's not like predicting like which way a ball is going to roll down or something. This is a situation in which
we can be pretty confident. We can be pretty confident that the majority of Republicans who last time around overwhelmingly supported Trump and currently, not overwhelmingly, but majority of them support Trump. We can be pretty confident that those Republicans are going to be very upset if he is taken out of the running and doesn't lose in an election that they consider to be fair, but rather is kept out of the ballot. Right?
I disagree. Can I jump in, please, as one of the conservatives who did vote for him? And again, if he's on the ballot and I was in a state that actually mattered, because I'm not, but if I was, I would vote for Trump over Biden. And I would say no, because I think the direct result of it will be mistrust from a lot of the Trump supporters initially, right? But if we're talking about stoking division, it sounded like more of an overall question of what's going to create or minimize division in the overall United States over time. Trump in the GOP has stoked more division from GOP loyalists against everybody else than removing him from the ballot ever would. And having him retake the ground that he has lost through all of these court cases and through all of this January 6th mess by putting him back on the ballot and having him maybe beat Joe Biden in an election because Joe Biden's polling poorly. I don't actually think he would win, but if he did, would do much more damage over time. It would cause much more division over time to continue the GOP's Trump trap, where the vast majority, not the vast majority, I would say half of the people who are polled right now as voting for and supporting Trump are doing so because they think they have to in order for the GOP to win an election. From someone who is conservative and who runs in mostly conservative circles and talks to a lot of conservatives, most people don't actually like Trump that much. They're fine with him. They don't hate him. I mean, it is. His approval ratings were record lows. When he was in presidency, even among Republicans, he had pretty low approval ratings relative to other Republican presidents. His support in terms of people wanting him over everybody else, just purely out of wanting him, they're not like remarkable. They want him because they think he'll win an election, which is fine, but I don't think that him leading the GOP for years to come will reduce division. I think it'll maximize division, and I think giving them the excuse they need to move on to other candidates will... What do you mean?
The question wasn't whether or not
get you in, Johnny, right after
Trump being in power. The question wasn't whether or not Trump being in power is good for or bad for division. The question
But it
was
is,
whether
though.
or
It
not-
is.
No,
Because
no,
when
no,
you
it's
say,
very
hold on,
specific.
stop. Let me
Question
explain why.
Hold
Let me
on.
explain why. I understand what you're going to say. The question was about, in isolation, will this decision cause more division or less division? I'm saying you can't look at the question that way because there are consequences and externalities that come as a result of each decision. And I'm saying that to say that removing him from the ballot is going to cause division in a vacuum
You
is
can
to completely
contextualize the
stop
answer
and
to the
let me
question.
finish the answer. It's very
Yeah, go for it.
like 10 more seconds. It is to ignore how much division will be stoked by him returning, by him maintaining his stranglehold on one of the two parties in the United States, as opposed to letting, and if you think I'm wrong, we'll see what happens if he gets removed from the ballot, giving them their excuse to get a different person who is more willing to work across the aisle and capture moderates than Trump is. I think that'll reduce division far more over time.
So,
If you were
Jeb,
answering
my
a different
extension
question
of
than the one that
Lex's
Lex
question,
asked.
excuse me one
Hold on.
second. Thank you
Johnny,
so
go
much.
ahead.
Go for
My
it.
extension of Lex's question for you, Jeb, because you seem to be the most qualified immediately to answer it, which, by the way, Lex, shout out to you. I don't know you, but apparently some people in my chat love you. Is that, do you think that, and this is not how it's going to happen, do you think it would cause less division among conservatives or conservatives among the rest of America if Trump was first convicted of some sort of treasonous act and then excluded rather than simply being excluded?
Yeah, no, it would cause marginally less division. The reason I say marginally is because what I'm trying to express here is that the Trump loyalists, like the MAGA loyalists, even if he is convicted, they are going to say that it was a faulty conviction. And it's not, so there are going to be some people who are truly on the edge. They are a small minority, and they will be convinced by a conviction that, okay, maybe even if it is a sham or whatever, like, what is the Supreme Court going to do? You know, they got to remove him. The vast majority of the people who are actual MAGA loyalists aren't going to give a fuck about a conviction. And I think genuinely half of that 51% or whatever of the GOP he still retains in polls are people who would gladly take any excuse to vote for the next person down on the ballot if they knew that that person was their option best positioned to beat Biden. Right now, there's no evidence that any other candidate is better positioned to beat Biden than Trump. That's why I think Trump has half the support that he has, is he projects this idea that he's capable of beating Biden.
A question to the pro removal side, and this is from Artemis Fowl, and it's a good question. I think he didn't frame it as a question, but I'm going to frame it as a question. Say in Texas or Tennessee or another red state, the Supreme Court of that state rules that Biden has engaged in corruption based on all the accusations that have been levied at him from the right on corruption and high crimes, misdemeanors, et cetera, et cetera. Say they take that without a conviction, they hold a trial, 7 days, they have witnesses, but then they remove him from the ballot. Would that be something you would support? Why or why not?
They have
We
the
would
legal
not
right to
support
try
that.
it. Well, hang on.
They
They
can
have
try it.
they have the legal right to try it. Just a couple of things, because there's some things I think that Quibble raised, which I think he needs to. I would like him to contend with, because maybe he has a good answer. Republicans abusing something should not be a reason for us not to pursue the law. Republicans are the Republican Party is generally a bad faith party. They abuse institutions and norms, okay? Will they, as a result of the Colorado decision, attempt to keep Biden off the ballot? I'd be surprised if they didn't. You had the lieutenant governor of Texas openly threatened to do so as well. So it's entirely possible. If, again, that's supposed to keep people from pursuing the law in other ways, because if you do that, then it opens the door for Republicans to retaliate in a vengeful tit for tat, then we should just not do anything, right? Then they get to run the show.
Yeah,
Right.
It shows that,
well, hang on. That's not what I was.
Section 3.
That's not what I was getting at, Quibble. Hang on. So I've got something for you specifically. But to Quibble's point, going back to Lex's question, again, I think that's a perfectly fair question to ask from a utilitarian philosophy perspective. The idea that would pursuing the Constitution here create more division than good? But people were asking that about charging Trump criminally. If you hold Trump criminally accountable or civilly accountable, aren't you creating more division? I think that's a fair question too. But I think if that's where you err, I think you have to admit that, listen, for the good of the country, we have to put Donald Trump above all accountability. We have to put him above the Constitution. We have to choose not to prosecute him for prosecutable crimes, because doing so will cause more harm than good. The only way I will ever entertain that argument, and I'm somebody who says I would entertain it, you have to admit I'm putting Trump above the law and above the Constitution for the sake of the greater good. Conservatives who don't admit that are just bad faith.
Yeah, that's not what I'm saying at all. What I'm saying is this. When Lex asked his question, he asked a very specific question, which was whether or not just the question itself of the fact that Trump was barring Trump from being able to be part of the election, is that itself going to ratchet up or decrease tensions? That in and of itself. That's a different question than the other question, which is what Jeb was trying to get at, which is the question of whether or not Trump winning is something that will ratchet or decrease.
Whoa, no, Jeb, no. I just want to stop right there because I have a disagreement. Jeb absolutely addressed the first question. What Jeb responded to you is that you cannot disentangle the secondary effects of keeping him on the ballot. Okay, so you looking at in a vacuum like.
I agree with you. But the point that I'm trying to build here is that I think that it's worth being able to answer those as individual questions, just as it's worth being able to answer the question of constitutionality as a different question than the question of the impacts that it'll have on the short term and the long term. This question of whether or not we're going to have this Biden being similarly prosecuted in a similar way. All of those questions that are different.
Yeah, I did. I said in the short term it will stoke.
Hold on, one at a time. I want Pisco to finish, and also Pisco, if you, I guess people are asking
getting someone to get. I'm getting someone to get a camera, so that will be provided. So Quibbles. Jeb answered both, and what Jeb said, and what I would agree with for sure, is there are people who will absolutely be increased in division and will be more extreme and will be radicalized by any kind of decision affirming disqualification of Trump. No question. But it would be like analyzing in a vacuum, like, well, did this bomb kill one citizen? And be like, yeah, it did kill one citizen, and so therefore was the bomb justified? Like, no, we would look at the secondary effects of the bomb or the situation, whatever it is, and look at the long term. With I think that's what Jeb was saying, is that in the long term, it's kind of a harder question to see whether.
So then we can. Okay, awesome. I agree with this. All of this is valid, and then I think similarly, then there's this question in terms of when you're talking about constitutionality here. There's this broader question. And I want to be clear that this is a broader question that is not, by asking this question, I don't mean to cede the matter of whether or not it's constitutional to do as individual action. But there's this broader question, which is what I think is part of what I'm hoping to get at, which is like, constitutionality is something that happens on the individual momentary basis, but it's also something that we're trying to protect in terms of long-term precedent and norms. And the long-term precedent and norms issues, which I think is something that Josiah was getting to there, about the impact this is going to happen, that Texas is going to go after Biden in similar ways and all of that. The long-term precedent of going after a president in this way is third world, despot behavior. The long-term precedent is that we're going to have this kind of thing done over and over and over, not just in the 24 election, but in 28 and 32 and all of it. And that's something that I think is going to have a really bad effect on America more generally.
Okay, listen, fair enough, but let me ask you an alternative. Do you think it's third world, or banana republic is the phrase we hear a lot, to not hold former leaders accountable when they commit either criminal acts or betray their supreme law of the land, the Constitution?
I think that yes, it is certainly third world.
So right now, so you presented
can I flesh it out fully?
Sure.
I think that it's important that we hold them to account, but I think that it's important to hold them to account in terms of the political, from a political avenue, and the way that we should hold them to account from like a sort of issues of like interpersonal grievances. That should be held in a different category. So when they're doing something that's like fucked up in terms of I'm sorry, what did you say, Jeb?
Sorry,
Pisco just did.
Yeah.
Was like,
He's gonna
I
throw
think
his
he's just
camera
going
on,
to set up
I
his
think
camera.
I think he's messing with his camera.
Yeah.
Um,
I think that when we're talking about something like this is something that should be, I think, held in the political realm. We should be responding to political issues broadly, and this is a different conversation than constitutionality. Let's be very clear about that. But in terms of the impact that this is going to have in terms of the long-term precedent for our country, I think the long-term precedent of having political issues be handled politically and issues of like personal behavior and like just normal day-to-day crimes of everyday people, that kind of thing should be handled in something that is a different context.
I'll be honest with you, I'm not sure I understand. Could you? I did not.
I understand.
Yeah.
I think, and I want to cover it a little bit.
I want the president shooting someone to be handled in the same way.
Wait,
as
hold on.
shootings.
Hold on. Just
Yeah.
a second for that.
Political
Quibbles.
that is
Quibbles.
bad. That should be handled.
That comes to a question. The day before election, on national television, one of the candidates shoots someone. We all see it. There's no justification. They're like, ha ha ha, I'm going to shoot someone. Bang. Right? And the person dies. Now, they aren't being put on trial, right? They don't have time to be put on trial. There's no time before that in an election. Would it be amenable for states to decide, because we all saw this happened. No, we haven't had a trial
he's
yet.
Backstage.
But
sorry, he's backstage.
Yeah,
probably not, Wick.
No, yeah, I would say no 100% on that, because the issue is, one, there's not a stat like and that's what I wanted to cover with Quibbles, was this idea that presidents are going to be handled too strictly. I don't know what we can do more than what we already do for presidents. They're given absolute immunity regarding anything that actually has to do with their job as president, right? So they're absolutely immune regarding anything that is part of their job as president. They're giving wide deference over the entire U.S. military to do whatever they want and never really get tried for war crimes, which, again, I'm okay with that. We just draw the line at, if you do anything to directly rebel against or insurrect against the actual United States, that's where we're going to draw the line.
So, to be clear,
that sort of
to be
fights
clear,
against that argument.
In that case, in that hypothetical situation where, again, a day before the election, one of the candidates shoots someone on national television and tells everyone, I did it and I liked it and it was fun, right?
It'd be up to Congress, not a district court.
Mm-hmm.
Yeah, and I don't think that even necessarily disqualifies you.
Yeah, so this is important. I wanted to answer something that Johnny Scarlett said a little while ago. There was a question presented of, well, if the third article of the 14th Amendment was intended to prevent former Confederates from taking part in government, obviously it would be ridiculous to assume that we needed some kind of statute or some kind of legislation to just prevent that for every single one. And that's actually not true. And a year after ratification, the Chief Justice of the Supreme Court, writing circuit, in Griffin's case, quite literally did decide, no, actually, the Article 3 of the 14th Amendment does require that there be legislation. And a judge who was priorly a judge of the Confederate States of America was not removed from their post, specifically because there needed to be legislation in order to back up Article 3. And the common sense here actually runs counter to the disqualify Trump position, because if the assertion now is, okay, well, actually, it makes more sense that Congress intended for district courts to be able to do this, then that must mean that Congress intended for former Confederate district court judges, potentially, in the South, or those with Confederate leanings or Confederate sympathies, to be able to remove names from the state ballots without Congress's approval. Would it make sense? Here, let me ask you this. Would it make sense that Congress intended for the 14th Amendment to allow, let's say Lincoln had not been shot and had like another term, let's say. Do you think it makes sense for Congress to pass this, the third Article 3 of the 14th Amendment, with the intention of allowing a Mississippi district court judge from removing Lincoln from the Mississippi state ballot? Do you think that would actually make sense?
It does make sense, because they installed Republicans. If you go back, and it's just a matter of fact that the Union Army installed Republicans to run the governments of the southern states.
During the occupation, but not once they were readmitted.
Yeah, but hang on a second. It is a matter of fact that many of these states, including Texas, including all the southern states, for a period of time, even for I think decades, Some had Republicans holding top positions in all these places. There's nothing inconsistent about Section 3 being enforced by Union-supporting Republicans installed by the army, and then those in control of the states that were in rebellion. And furthermore, let me just finish. Just let me finish. Furthermore, it would be weird for every other part of the Constitution and the 14th Amendment to be enforceable by the states except for Section 3. Where is the rationale for that? Equal protection claims heard in state courts. Due process claims heard in state courts. I mean, do you want to go down the line? These are all heard in state courts. Why would we build in a non-textual limitation and say this is the one area that's not enforceable by Section 3? Or sorry, by the state courts.
So I brought up stare decisis here, which is a settled case, right? Which is Griffin's case.
It's not. That's not binding precedent.
Hold on. It's literally from the Chief Justice, and it's the first interpretation that is cited.
It's not binding.
It is literally cited in cases up until in the 1970s.
It's not stare decisis. I don't know how many other ways to say it is not.
It's cited
stare decisis.
Okay, it's cited by a number of other courts. All the way
is
up
it binding? Yes or no?
I don't know if the courts that decided it later and echoed it were binding on Colorado.
This isn't even disputed by Trump or his lawyers. It's not binding.
Hold on. I'm saying I don't know. I'm saying I don't know if the Supreme Court or the cases that came later up until the 1970s, if those decisions were binding on Colorado or not. I don't know. Okay.
None of them. No. This is not even contested by the parties.
Hold on. Pisco, please. So you're saying it's not contested. I'm telling you I don't know. So unless you know
I know for a fact it's not binding.
All right, then list me the 1970s case that you know for a fact is not binding on Colorado.
So this is, you said it yourself. This was the Supreme Court Chief Justice riding circuit. He was not ruling on behalf of the Supreme Court of the United States. And I know for a fact that it's stipulated in the briefing and in argument in front of the Colorado Supreme Court that the decision of that decision is not binding precedent on Colorado. Of course not.
I understand the Supreme Court did say that particular decision was not binding on Colorado. Okay, I understand that. What my question is I'm not sure, and until I get it verified, I'm just going to remain agnostic about it.
Okay.
If any of the court cases later, if any of them were binding on Colorado, I don't know. It's very possible that they weren't. But for Johnny's question, this is important because in that case, it was not a judge appointed by the Army. It was a former Confederate judge appointed by the interim government of Virginia, which was elected with like some caveats from the Union Army in terms of they were allowing certain people to be, limiting their powers, making sure they couldn't do some things, they could do other things. But it was elected by the populace there, who were former Confederates. So you have a judge who was a former Confederate in a former Confederate state elected by an interim government, and the Chief Justice writing circuit specifically said, the 14th Amendment was the third article of the 14th Amendment was not meant to be self-executing in this case for a number of reasons. One of which I said, which is it'd be ridiculous to give this power to district judges in the former Confederate States of America.
Yeah, he was wrong.
Because of what Thaddeus Stevens, one of the framers of the 14th Amendment, quite literally stated in both the final form and in one of the prior forms that the third article was not meant to be self-executing. Thaddeus Stevens, you can look it up. Literally one of the framers.
It's bizarre to me, and this is the second time now. This is the second time now that you've cited legislative history when I thought that we should not be looking to legislative history to help us interpret the meaning of text. That's what I understood.
I've never taken that position.
Putting that aside, putting that.
I have never taken that position.
Okay, putting that aside. Wait, I want to just respond to this real quick, and then I'm happy to hear your thing, Quibbles. So the Chief Justice was wrong in Griffin's case, and the opinion is bad. It relies on the same kind of thinking that, I'm sorry, even though it's understandable prudentially why they're concerned and why Quibbles is concerned and why, Lex Friedman is concerned, right? But it's based on like his priors on the prudence of doing it. It's not an opinion based on a solid understanding of what the words say and how it's intended to operate. And it's not binding. And so it's not a precedent that we have to contend with as any dispositive ruling on how the Section 3 of the 14th Amendment operates. And so,
what you're saying in summary,
Well,
What
so
you're
real
saying
quick,
in
one
summary
last
is
thing.
okay. Yes.
Well, it's interesting how, again, the specific case I brought up, we've moved off. Well, the Army appointed all the judges because in the very first case that heard this question, it was not a judge appointed by the Army. In fact, it was a judge appointed by the interim government,
and he came to a wrong decision.
And he was a former Confederate.
He came to a wrong decision.
Yeah, I understand you disagree with the Chief Justice of the Supreme Court writing circuit. I understand you disagree. But what I'm pointing out here is that it's not obvious that the third article of the 14th Amendment was intended or understood to be self-executing if the framers didn't agree it was, if the Chief Justice of the Supreme Court writing circuit did not agree it was. And when you get in these circumstances, there's case law for this too, like when there's a dispute, it's got to be clear if you're going to go against the voters. And in this case, that's what they're doing because they're just qualifying
Is the Equal Protection Clause self-executing?
So it depends if it's used as a sword or a shield. If it's used as a shield, it's commonly understood in terms of protection of an individual from state power. It's commonly understood through a number of cases that it is self-executing. But it's not necessarily as a sword. It's not self-executing, which is why if you want to use it as a sword,
how do I know if something's being used as a sword or shield?
When it's being used as a sword, that means it's using is the government using it to compel or to go after somebody, or are they using it to defend an individual from government power? So, for example, the 14th Amendment is not self-executing when it comes to the Civil Rights Act. We had to pass a fucking act for that because even though you could potentially fucking intuit, well, the 14th Amendment requires equal protection, which then requires that we disallow hotels or we disallow like different businesses from allowing black people. No, it doesn't follow. If you want to interpret it that way as a sword to compel private actors to do private things, you need to have some kind of legislation.
The Civil Rights Act is done.
To ask to summarize this because what you two have done is you have gone back and forth and you have argued essentially that this Section 3 of Amendment 14 has said 1 year apparently post its induction that it was in that 1 year interpreted by what Lactoid said that there needed to be some sort of trial. It was not self-imposing. What you have said, Pisco, is that that did not set an absolute precedent for the rest of the findings via this amendment. Is that correct? And further to my question, is it not, it is then my understanding, and albeit a very layman's understanding, is it correct to say that it could be interpreted either way based on the precedent within the state?
Yeah, so I agree with what you just said at the end there, that there's this case of Griffin's case where the Chief Justice of the Supreme Court writing circuit, which means they used to send out these justices to go do like their intermediate appellate work in the various places. They would like literally go take these dangerous like horse rides across the country. And so that's what it means when he says riding circuit. It wasn't the Supreme Court speaking as the Supreme Court. And so there is this case called Griffin's case where oh my God, Samuel Chase, who's the Supreme Court the chief?
Yeah, I think it's Chase.
Salmon or Salmon.
Chase, I think was the judge that was like
yeah.
Okay, got it. And so there was a case in which this judge was like being argued it wasn't eligible for the office he had because, as you know, Section 3 disqualifies you from like a crap ton of different offices, including state offices. And what the court said, that is the Chief Justice sitting riding circuit, is that Congress needed implementing legislation to enforce this, and I can't just enforce this sitting here on an appellate posture and say, what the conviction is invalid. So that's the historical practice pointing in Lactoid's favor. Okay, so there's that case, but there's historical practice in other people disqualified not via the methods of congressional enactments.
Because he's provided specific examples and
sure.
Again,
yeah. So there's both examples of a state, I believe, quo warranto statutes where people were disqualified by state procedures, and there's also specific instances of congressional, not via enactments, but congressional disqualifications and expulsions, like what happened to George Santos for people who were admitted as representatives and who were then expulsed. The process of expulsion was given to them, and they were kicked out of Congress, right? So that's not via a a constitutional statute. That's through the inherent authority of the bodies to get rid of the. Well, you can. Haven't you read the Baden-Powellson paper? They cite the specific expulsions that occurred by name, and they cite the state actions that were taken.
No, I also read the paper that criticized it.
Okay.
I forget the actual.
Okay, no, but you can't deny that those things happened.
Well, no, I'm asking. So I don't deny that.
I can pull it up right now. But
yes, you're right. It's hold on. There's a very conflicted history here, where you have a whole bunch of people who didn't even hit the age requirements that were allowed in. You have some people that didn't hit the age requirements that were not allowed in. There seems to be like a very spotty history of this being consistently enforced. I don't disagree with you, but my question is, do you have a court case? If anywhere, really, if anywhere in the country, a court case indicating that actually Article 3 is self-executing when it comes to removing somebody's name off a ballot or removing somebody from office?
Yes, there are. I mean, but here's the question. If I produce it for you, will that change your position?
I'll read it.
Hang on. If I produce you a case in the 19th century of someone being disqualified from office, either through a quo warranto action or some other equivalent process in a state system, will you say, okay, it is self-executing and the state's going to apply it? Or will you just shrug your shoulders and say, whatever?
No. What I'll say is what I said at the beginning of this, which is I do think this is a decision for the Supreme Court. I do think there's a spotty history here, and it's an interesting question. I've listed you a case which I think is extremely compelling. If you have any case law that I can take a look at, that will be evidence in your favor. But just because you can list evidence in your favor doesn't mean I'm automatically going to agree with you. Griffin's case is pretty convincing, and Thaddeus Stevens, one of the framers of the Article 3, is extremely convincing. You have somebody who literally drafted this shit saying, I never intended for this to be self-executing.
I mean, so basically, as you know, there's legislative history that goes both that goes both ways, and to sort of respond to your your absurdity question, it seems absurd that what the framers of Section 3 wanted was for all of these people to go through criminal processes, or for us to have individual cases with respect to like every individual who was engaged in the Civil War. It seems much more likely that this was meant to apply broadly and to work automatically. And the very words by their own terms apply automatically. We don't need to look to additional legislative history if we just look at the text here. The permissive grant of legislative authority in Section 5, that applies to all portions of the 14th Amendment. Just like in the 13th Amendment, there's a permissive grant of legislative authority, but no one doubts that the 13th Amendment was self-executed and the slaves were in fact freed as soon as that amendment was passed. Why should we not think that just like the other qualifications of the Constitution, or just like the 13th Amendment, or just like the Equal Protection Clause, these things are self-executing? Now, what you've pointed to in the Civil Rights Act, and you've said, well, it didn't do what the Civil Rights Act did. Of course it didn't do what the Civil Rights Act did. This is a permissive grant of authority, and the Equal Protection Clause, there's limits to what
permissive means not self-executing.
There are limits to what courts can do acting as courts, but that doesn't mean that it's not self-executing, right? Like,
wait a minute. Hang on. So I'm a layman
I want
here.
to get some other people in here. Go ahead, Josiah, then go ahead, Quibbles.
So as a layman here, between this dispute between Pisco and Lactoid. So and again, I'm not sure if the legal history here is correct, but wouldn't the Civil Rights Act be an example of Congress exercising Section 5 permissions from the 14th Amendment, which again, it doesn't say Congress will pass enacting legislation.
13th Amendment, by the way, it's the legal argument for for the Civil Rights Act has been the badges of slavery that are inherent in the 13th Amendment.
Right. So the idea, again, I'm a layman here when it comes to law. So tell me what I'm missing here. The 13th and the equal protections under the 13th, 14th Amendment, they applied even prior, like they were self-executing, but Congress passed the Civil Rights Act in order to, I guess, expound on it and codify it further. It's not like it was an inoperative amendment prior to the Civil Rights Act, right? Nowhere does Section 5 require Congress to take any additional steps. It just grants them the authority to do so, right?
No, but it would require them to pass legislation if they want to do the kind of stuff that the Civil Rights Act allows them to do. You can't just do the shit in the Civil Rights Act without passing legislation by saying, well, the 14th Amendment is self-executing. It grants courts to decide that certain people can't discriminate against other people and businesses. That's not the way this works, right?
So can I ask
Real quick, legislative history here is critically important. The fact that specifically for Article 3, the framers were saying that it's not one of the key framers said that it's not self-executing. The fact that the first case from the Chief Justice a year after its ratification also said that it wasn't self-executing, which, by the way, has not been overturned as far as I'm aware. Seems to be, at least to me,
it's not been an issue.
It's not been an issue, but it has been cited by multiple courts since then favorably. Right?
It has, but it didn't set what was cited as permanent precedents. And so my question to you, 𝕾𝖏, is why would we, in what cases do we go exactly by the letter of the law and what is actually codified? And in what cases do we decide that we need to also look at the journal writings or what the fuck ever, of who wrote these legislations and what was actually codified?
Right. So if this was if let's say this justice, the Chief Justice, was writing circuit in Colorado, that federal circuit, and made this decision, that would be binding on Colorado.
I'm not so sure about that. That's a federal.
How are you not sure?
Because that would have been not that's federal precedent. Just like when have you been following the Wisconsin elector situation, the Wisconsin district situation? So that in that case, there was a federal district court interpreting some provision of what's required, the continuity requirement and that wasn't binding on the Colorado court because that's an interpretation of Colorado state law, and the line of authority isn't direct as between the federal courts located in Colorado versus the Colorado courts of the state of Colorado. And so unless you had good.
Let me amend what I said. So that's a fair point. It would be extremely persuasive, I suppose, because now you would have a state law that's in direct conflict with a federal ruling in that same district, right? So now you've got an immediate issue.
But just so you know, New Mexico disqualified someone, and there was a pro warranto statute there, and they just kicked him out of office. That's also an issue. That also conflicts with Griffin's case, and so it just is the case that there are a lot of people who disagree with Griffin's case, and it's not binding on New Mexico, and it's not binding on Colorado. We are yet to hear from the Supreme Court. Now, the Supreme Court might ultimately say Trump's not disqualified. I actually think if you were to be a betting person, I think it's a more likely outcome, not because they're right on the law if they would do that, but because I just think that this is a
so that was one of three.
Let me finish my.
Okay, once we finish, there's just real quick before you go. Right. Once you finish, we do have an order of operations here, right? Quibbles needs in, and then Josiah has.
Sorry, guys, my bad.
But we do have to get some more people in here. But go ahead.
I'm not super familiar with the New Mexico situation. I don't know what things went on beforehand that allowed for that removal.
It was Jan 6.
Hold on, please. You're okay. So if that was done improperly, I would hope that the Supreme Court, when they hear this, would overturn that as well. I'm curious.
It's done and dusted. I guess he would be undisqualified if
I guess he would be undisqualified, right? So to answer Johnny Scarlett's question, though, the United States is a federal system, so there's different jurisdictions and different people at different authority depending where you go. If in Griffin's case, the Chief Justice was in the Colorado State Supreme Court, let's say there was a weird system back then where you rode circuit for state Supreme Courts or whatever, and he came to this decision, then this would have been binding on Colorado, and Colorado would have to follow the letter of the law there, unless I guess they overturn themselves, but then that would go, obviously would have to go to the Supreme Court, which is doing so anyway. But that said, right, you can still use cases from outside of your jurisdiction to argue particular points of view as more convincing or less convincing. And when the question is a very reasonable question, which is what did they mean when they drafted Article 3? What did they intend for this to apply to? I have never been opposed to using legislative history to look into this. I think, in fact, although I don't think it's particularly persuasive, when the Supreme Court of Colorado uses a conversation between two congressmen to come to their decision that the office meant the president as well, that is evidence that I think should have been cited and definitely should be in the record and taken a look at. I don't think it's dispositive. I think there's other things that are more compelling. But like all the evidence taken together, I think indicates, at least to me, that there is a reasonable argument. There is a reasonable argument that the Article 3, because of the framer and because of the initial case coming out of it, and the fact that it's been praised since then, that Article 3 was not meant to be self-executing in the way that other parts of the Constitution are.
Okay.
So, okay, a couple of things here. So, no.
Well, hold up. I'm up. I'm sorry.
Yeah.
It's my turn. So I'm curious about this in terms of the self-executing component. If we can get back to the shield sword analogy, I'm curious about that component. Pisco, are you comfortable with the analogy of shield versus sword?
No.
Just in general, you're not.
Yeah, it's super not helpful. Yeah, because and I'll tell you why.
Okay,
because
so
you can think of these both as swords of shields. Like the equal protection clause, to the extent that like you're striking down some law that says, let's say it burdens black people. Is that is it a shield defending black people, or is it a sword striking down the democratic desire of these people to put a burden on black people, right?
My understanding is essentially innocent until proven guilty as like a basis of the shield versus sword distinction. Perhaps, admittedly, I'm a layman, so that may be incorrect. But my understanding is like 13th Amendment being self-executing because like freedom is the assumption, and then only if you can have evidence that they're guilty of a crime, therefore they can still be enslaved.
Well, hang on a second. I mean, my response. Listen, I detest slavery. It was correct to get rid of slavery. Slavery is abhorrent, and I disagree with it on every possible level. But as everyone understood,
just breaking news. Breaking news.
Yeah.
Trump was just removed from the Maine primary ballot. So.
Oh wow!
Just
correct decision.
FYI.
I'm high-fiving Jeb-Tan right
now.
Well,
I shouldn't say correct decision. I don't know about Maine law, so it could be incorrect depending on Maine law.
No.
So,
you just fucking
get over here, baby.
This is me regulating myself. It's correct on the underlying merits, but in terms of Maine law, I don't know Maine procedural law, and so in all fairness, I can't say that the Secretary of State is correct because I don't know.
Sort of
the partisanship comes out.
I'm just referencing the merits, and you guys all know my opinion on the underlying merits. I don't know about whether this was procedurally proper under state law, and you can think of that as kind of like a threshold question on enforcement, even if it's self-executing. I know you were sort of memeing there, but like if that's what you jump to as your meme of like this is correct, but you're not basing it off of Maine specifically. You're basing that off of something broader, which implies that it's getting to the sort of utilitarian. Let me explain why my reaction was that and why I stopped myself. Okay, so my initial reaction to that was Trump is disqualified because if you apply Section 3 of the 14th Amendment, it clearly disqualifies Trump and his conduct fits it. We can have a disagreement. Llactoid absolutely disagrees. He thinks he's on.
I'm not. So I just looked at it. It was not a case. The Secretary
of State, they just decided it.
The Secretary literally just unilaterally said he's off the ballot.
It's going to be reviewed. Okay, calm down. I promise you, all will be revealed. I promise you. So my gut reaction to people disqualifying Trump, in terms of the merits of the Section 3 argument, is it's the correct argument, and so I'm in favor of enforcing the Constitution. Now there are threshold enforcement issues, right? Like if I just decide today myself, hey, I'm going to disqualify Trump from the New York ballot. I don't have the power to do that in New York. There's a separate threshold question about in any particular jurisdiction or through any particular process, does this even have the power? In Minnesota and in Michigan, they decided as a matter of state law, courts did not have, in those states, don't have the power to enforce Section 3 for purposes of the primary. And so in Maine, it could be that the Secretary of State has the initial decision to decide whether or not they're qualified or not, which is reviewed by courts. Yeah. Or it could be that the Secretary of State doesn't have the decision. And my belief on whether or not it was right will depend on Maine-specific law vis-a-vis enforcement.
Yeah,
so I don't know the answer to this component, but I'm curious about this. Obviously, the RNC and the DTC are not governmental institutions; they're private institutions, right? So, like, this is the argument.
Who's private institutions? Say it one more time.
The Democrats and the Republicans, the DNC and the RNC, are not governmental institutions. So, I'm curious.
Correct.
Do you think that they should be allowed to be making that government decisions should be made in reference to this at all?
So there's a First Amendment.
General, obviously, yes.
Right. So there's a First Amendment issue that's been raised unsuccessfully by Trump and the Republicans. It's not an amazing argument, but it goes something like this. The Republicans have a freedom of association, with who they want to elect. So if they want to nominate a chair to be their nominee and put him up as their bona fide candidate, then you can't stop them because that's a First Amendment consideration to stop them. Now, my response to that is, sure, you can't stop them from nominating a chair or a child or a Saudi citizen from doing that, but the government is not required to put them on their government ballots. And you have Neil Gorsuch actually to thank for a decision on that front where there was a naturalized citizen who wanted to be on a ballot, and Gorsuch said, hey, you have every right to, like, you can say what you want, but you don't have the right to be on these ballots. And so that's the kind of First Amendment argument. I agree that they have an associational right, but it doesn't mean that they get to force themselves on the ballot if they're not qualified.
And in regard to that,
there's therefore broader like legitimacy to government intervention on something like superdelegates, for example. Like, do you think that this is a broader thing?
No, I don't think governments have necessarily a right to tell the Democrat and Republican Party how they want to run their nominations. There's some intersections in terms of using the instrumentalities of the government, right? Like, if you're asking the government to provide you places and voting processes to do it. The Democrats can decide tomorrow, we're getting rid of the primaries, we're getting rid of the all this, and we're just deciding, right? Like,
I'm asking a very specific question. If the Republicans decided to run a primary exactly as they're doing currently, but they printed their own ballots, would you be comfortable with that?
Would I be comfortable in a policy sense, or are you asking me would I be comfortable from a legal sense?
Policy.
I am not. No, I think it's good that the parties have moved. From a legal perspective,
they can just caucus.
They can just do that. They could just do that. Yeah, for sure. And I disagree with them doing that because I think that more democratic input.
Legally, you'd think that is a legal thing for them to do.
Correct, but again, that would be them having their own ballots privately, not involving the state apparatuses. There might be some other issues I haven't thought about, but generally, yes.
So from a legal perspective, you think that it is a legal thing for Republicans to respond to this entire thing. This could be done at a nationwide level. The response could be that they simply change this one slight difference, which is to say that the ballots themselves are no longer on paper understood to be government ballots, but rather understood to be Republican or Democratic.
They could do that, ballots. But then eventually they have to go to the general, and once they get to the general, you can't get away from it, right?
We're talking about the primary first.
Yeah,
right?
I agree. They could change their whole process, and this would be obviated because there would be no way for you to challenge their authority on appointing their candidate. But of course, you're going to have a trouble when you try to nominate them. Put them up for election in the government ballot for the general. That's what I'm saying.
This entire thing hinges on a technicality, which is that the pieces of papers are printed by the government and not by the Republican Party.
Here's the technicality,
only
right?
in the short-term sense. In the long-term sense, this is the reason why these questions are kind of annoying, just like the way you framed the Lex Friedman one, is because when we ignore like the actual end result of these, it becomes we're talking about nothing for 20 minutes. This is let me elucidate my reaction in response to what you guys are saying. The reason my reaction is positive is because Section 3 doesn't talk about primary ballots. It doesn't even talk about general ballots. It only talks about who's eligible to be president. And I don't want
that's correct.
all of my great Republic. Okay, stop.
No, it doesn't.
Stop. I don't want.
It doesn't include the president.
Well, if it does, theoretically, the reason my reaction is positive. Okay, just give me a moment.
Finish quickly, but then Josiah's waiting in the wings, just ready.
I got it.
Ready
yes,
to go.
Thank you. I've been trying to finish quickly, but some people keep trying to stop me. People with curly hair and glasses keep trying to stop me from finishing quickly. So my reaction isn't because I just think it would be so great for Trump to get suppressed by all these state leadership. It's because as a Republican, with a lot of Republican friends who are going to vote Republican, I don't want all of our votes being wasted. Because if Trump is on a primary and a general, and that's great for freedom, but then he's disqualified from being president, we all just voted in a guy who might win, and then we find out he can't be president, and then what happens then? The reason I'm happy is because I am guessing the Supreme Court is going to disqualify him 8-1. I think he will be disqualified from being president, and I don't want to waste
Supreme
Republican
Court,
primary.
the United States,
the federal
Supreme Court?
The United States Supreme Court, I think, is going to 8-1 this decision.
Just to be
What,
clear,
you want to bet on that?
I put 25 on it. I do a fun 25 bet.
You think 8-1? I'm curious who the dissent. Just real quick. Stop. I'm curious. First of all, if you're taking action on this, I went in on the action.
Hold on. But
two, real quick. Who do you think the dissenting voice will be?
I mean, who do you think the dissenting voice? Clarence Thomas.
Alito's going to dissent, bro. Do not. he is
I don't
100,000% going to
know.
dissent.
Okay.
Yeah.
Maybe.
And I think the chief is one of the most likely to dissent, to be honest with you.
Okay, well, we'll see. I'll talk to Lactoid about the.
Okay, finish your point though. And then
There's
we'll
But what
a
I'm
prior
saying
case.
is, when I show my enthusiasm, it's because technically all of these primary ballots and general ballots do come down to weird technicalities and whatever. The issue is whether or not he can be president. And as a Republican, even if you think it's unrighteous, even if you just guess he will get disqualified, you should, in a self-interested way, want him removed from primary and general ballots, because that's the best way to get the next best person in a position to beat Biden.
But then you should be having an argument with the Republican Party. Your issue is not.
I mean, this is an argument with both. Yeah,
You should be saying
right
to your RTC, "Hey, I don't want this to happen, and therefore I'd like you to bull this up the chain to the statewide level in order to be trying to push for that as an advocacy thing." But it's not something that's a legal issue.
Sure, whatever. That's fine. Yeah. That's fine. I'm saying the reason my snap reaction
belong in a conversation about law, if that's your response to it.
No, it is a legal conversation. No, it is a legal conversation
because
the current.
Well, hang on, because that's
this component isn't a legal conversation.
It is because there are laws specifically in states that have there are laws in states that require primary candidates to be eligible, right? So and the current way this is going to work is using the state apparatuses to conduct the primaries, and that hasn't been disturbed. There hasn't been some big agreement to circumvent those procedures, and so it is a legal issue about what is allowed on the primary and what's not, and so that means they're going to have to contend with it. Unless they change their approach.
But just to drive this point home, the other 3 points were like 7 hours away from it, so I'm just going to drop them. But just to emphasize quibbles, Section 3 of the 14th Amendment doesn't refer to ballots at all. It refers to the office. So to Jeb Tan's point, the question is whether or not the courts are going to interpret it like, hey, if this person is disqualified from holding the office, you can or cannot put them on the ballot in the first place. How could you possibly put a disqualified candidate on a ballot?
Because it's in my, as a Democratic voter, my self-interest for them not to put someone on a primary ballot that can't be president.
Right, but every single year, people literally vote for like Anakin Skywalker, right? Is that a matter of
okay? But that's
it's
okay.
like,
I'm saying it as a joke, but like also
that's a write-in though. They're not a person on the ballot.
So those ballots, oftentimes, if it were for an invalid candidate, there would be nothing illegal, and what would happen is those are get thrown out. If you vote for Jesus Christ, the Messiah, to be the president of the United States, that's going to be thrown out, and you can contest whether or not it's thrown out. But the truth is that you're not going to be able to put dead people to occupy office or inanimate objects, and those are going to be discriminated against. Yeah, and if it somehow
you're taking shots, but go ahead.
Listen. Jeb Tan is exactly correct, and so is Josiah, that this has to do with qualifications for the office. You could think of a situation in which, and the court might actually rule this way, where okay, he is disqualified, but courts are not empowered to hear it, and the only people who are empowered to do it are like Congress in an impeachment matter. They could rule that way and say the people who have to enforce qualifications are the electors. So when they all meet to decide, the electors are the ones who enforce Section 3. They could come to that conclusion, but ultimately, currently, it's a legal issue that people have to deal with about whether or not courts are empowered. And
you're saying the court would come to the conclusion potentially that he would be permitted onto the ballots both of the primaries but also of the general election.
So Lactoid is arguing right now. Lactoid is arguing that states are not competent to hear these claims because it would be absurd, and the only one who's competent to do anything about it is Congress. And so in that situation, the states would have no discretion to keep people either off of the primary ballots or the general. And his response would be, these claims can't even be assessed, and the only one who can assess it is either Congress or maybe the electors.
And so your response is, rather than having this understood at the level of once you are in office, understood at that level, which is where he's saying it at the level of the Congress, you're saying that instead this should be done at the level not just of the ballot, but specifically of the ballot at the primary level rather than at the general level.
Yeah, that depends.
Of institutions that are non-governmental. Right?
So this is kind of weird too, because one way that this is going to be fucky is the Supreme Court can't necessarily mandate enforcement everywhere, right? So you can think of situations in which you have piecemeal enforcement, because there are places in Michigan and Minnesota, there is just no state mechanism to enforce Section 3 claims as to primary ballots. They have been clear on that, and they are the final word. There's no appeal for the Michigan and Minnesota cases on that issue.
To be clear to your point, with Michigan and Minnesota, that's not just like when it comes to qualifications on the primary, can a 24-year-old try to put himself? Okay, so it's not just about Section 3. Okay.
Yes, right. Yeah. So Michigan and Minnesota is saying that there is no discretion in our state whatsoever for anybody to judge the qualifications of a bona fide primary person in a primary contest. Okay, so in that state, you cannot challenge the qualifications of one of these people. And so there's no enforcement mechanism there. But in Colorado, what the Colorado Supreme Court held is there is an enforcement mechanism to judge at the primary level the underlying qualifications of everybody. And you can imagine a situation in which, all right, Colorado has that mechanism, but Pennsylvania doesn't, but this other state doesn't. And so the Supreme Court could say, in order to resolve this question for Colorado, we have to decide whether or not he's eligible. They decide that he is ineligible, but other states just have to put him on their primary ballot because they have no way to get him off. And so there are serious legal issues about how this would be enforced, even if the Supreme Court determines that Trump is disqualified. And those are serious issues that aren't just like technicalities. They're going to affect the substantial rights of the parties.
I just want to play out what it is that happens in the case that this is decided in your view correctly. What you're proposing.
Well, just before you go on that, show of hands real quick. Who thinks that the United States Supreme Court is actually going to uphold this, other than Jeb 10? No one. Okay.
I don't know.
Not even these go.
Yeah.
Not even.
No, I think the odds are against it.
I've put it at 25 to 30% chance that they would affirm the court, but I think there's a lot of ways for them to dodge the issue procedurally. There are a lot of ways for them to say, hey, the First Amendment, you didn't meet the Brandenburg standard for incitement. This doesn't count as engagement. You didn't give them enough procedural due process in the trial, even though I think all those arguments are absurd. But I just see this court as the center of this court is Brett Kavanaugh, guys. And just even though I think the arguments are strong, and they are originalists to Lactoid's point, these arguments are absolutely originalist arguments that would appeal to someone like Amy Coney Barrett. Oh my God! Yeah. I just had a brain fart. Amy Coney Barrett. But like, I just don't. I think if you're relying on this court and Chief Justice Roberts, who's very greedy about the institutional legitimacy of the court, I think there are a lot of people who look for any opportunity not to say that he's disqualified, and so that's why I put it at 25.
I interrupted Quibbles. We're gonna let Quibbles go. Quibbles, go ahead.
Yeah, I want to flesh out a little bit what it is that I'm understanding Pisco is saying. So what you're saying is that potentially what could happen if this was decided in the way that you want to see it decided at the Supreme Court level would be that Colorado and other states like it would have, certain states, but not all states, would have it so that both Trump is allowed in the primary and also that he is allowed in the general. But other states, because it had already been decided that he was disqualified by the Supreme Court, he would not be on the ballot at all. Or excuse me, rather he would be on the ballot. And having been on the ballot, there's a high probability that he would win that primary election according to the RNC. They're not according to the government, because this is a primary. This is a private organization. And then having already won the RNC nomination, there is a high probability that even if he loses, he would certainly get many, many, many delegates going into the election itself, right? And when that election now happens, now you're going to see an election that is already won by the Democrats, right?
So there's a couple. Oh, sorry, you can finish. My bad. So I have some ways which this is different.
Yeah, just to go back to Jeb's point previously, or to Lex's question about the question of like whether or not this is going to have downstream consequences for people's trust in institutions, and particularly trust in elections. I think it is self-evidently obvious that an election that is literally rigged by the time of the general election, where there is a single candidate that can actually win this general election, that's obviously categorically an example of something that is not going to be good for trust in institutions, right?
Well, listen, I buy so
ways it can happen, but
so there are a couple of places where I'll do some interruptions in your chronology. But number one is, I've always said, and you can go back to my tweet like months ago, where I say, hey, Supreme Court is going to have a time problem here. And there are situations where if the Supreme Court rules after or doesn't tip its hand until after the nomination process, hey, now we have a nominee who the Supreme Court rules after the nomination process is ineligible, that's a disaster. So there's absolutely a timeliness problem. And when this
that goes
happens,
up to the RNC, right? Like, who then?
well, we're in uncharted territory there, Jeb. But like,
Yeah,
to Jeb's point is, that's not the only way in which this is resolved by the Supreme Court. They have a timeliness problem, and the Supreme Court's going to want to tip their hand fairly early in this process within the next 2 or 3 months, because guess what? Trump's going to be on the ballot in Colorado. Trump's going to be on the primary. They're not going to be able to fully resolve this case. The primaries are going to be done, folks. And so it's going to be either like the stay decision or something where they're tipping their hand onto which way they're going to lean. And how this will work out is essentially, if enough states see the Supreme Court tipping their hand or, ruling in such a way that it makes it clear that they're in favor of disqualification, you're going to have a critical mass of the necessary states to deny Trump the general election. States that are run by Democrats like Pennsylvania, states that are run by Democrats like Michigan, that the key states, right? They don't need all the states, which are going to say, hey, he's disqualified. Supreme Court says so. We're just going to follow it, or we're going to pass a law, or we're going to take some action like Maine. And listen, it's binding on us. The Supreme Court, they just said it. And in that situation, Trump will have literally zero chance of winning because those states are not going to run Trump. In which case, the RNC, they can try all they want to stamp their feet and insist with Trump, and certain states certainly are not going to follow the Supreme Court. You're going to have a nullification crisis. It's going to be a shit show for sure. But the end result is the RNC are not going to want to nominate Trump if he's ruled to be disqualified.
Like just that scenario, if I may, right, to interject a little, that scenario you laid out where Pennsylvania, right, and I'm in Pennsylvania, for full disclosure. Pull something like that feels like a fail state. That feels like the last time we have an election, honestly.
Why does it feel that way?
Well,
I mean,
what?
The opposite is that Section 3 should not be applied, right? So assume the Supreme Court agrees with me. And Supreme Court says, you know what? It is the case that this is what Section 3 means. Griffin's case was wrongly decided, and this is the way it's meant to be interpreted. It applies to Trump. When you say it feels like the wrong thing, the Supreme Court's the last word here, folks. And what you're saying is, essentially,
the opposite is
we shouldn't follow the Constitution.
No, the
right?
scenario, like, prosecute, just real quick, Quibbles, please.
Yeah.
Prosecutors have discretion for a reason, right? They do not have to prosecute every crime.
This is a mandate. It's not like that, right?
And the Constitution is a mandate. And this is also going back to this idea. Are we just going to say Trump's above the law?
Yes.
Can we all raise our hand and say who thinks Trump is above the law because it's going to be too dangerous to move him from the ballot? That's the core of the WhickTV. Yeah, I'm talking to WhickTV though. And that's the core of WhickTV's argument. Maybe we should just make Trump.
No, it is. No, it literally is. Quibbles. WhickTV is saying prosecutorial discretion, right? WhickTV just said, isn't there prosecutorial discretion? The discretion would be exercised in such a way.
Because the reason I'm saying that, to be clear, the reason that I'm saying that is because the scenario that you outlined where states like Pennsylvania or Michigan just kind of act kind of a carte blanche to do this.
Or following what the Supreme Court hypothetically ruled. That's what they're doing.
And not only that, but like I said, there is a self-interest for Republican voters if the Supreme Court seems to be leaning toward disqualifying someone from the presidency to not commit your votes to someone who will not be able to win the presidency.
In every single election after this, what will happen, and they will be correct, they will say that the election was stolen from us. And we can't laugh at them anymore because it literally was.
Never applying. That's an argument for never applying.
No, it's not. No, it's not. It's not an argument to never apply it. Here's what it's an argument for. It's not. Here's what it's an argument for. It's an argument for it to go to Congress. It's an argument for it to go to have this be done in the same way.
If it goes to Congress, will people complain about it? Will
if it goes to Congress, the same thing happens.
Say that it's divisive.
The same things happen.
The impeachment.
Wait a minute. This is where I want Quibbles. Wait a minute, Quibbles. You've been talking quite a bit, so let me ask a fucking question, please. So, if you're taking and I told you all the way back 2 hours ago, I am sympathetic on paper to your position and to WhickTV's. But here's where I want you to satisfy me. Lay out a fucking scenario where this goes your way, but that Donald Trump is not above the law, where he's not above the law, where you pull out the big fat dick of the law and slap him in the face with it and let him know he's the law's bitch. Lay out a scenario here.
Yes, absolutely. Let's be crystal clear. Number one, when you're asking that question, you are presupposing that he is guilty of insurrection. Yes?
But
Sure.
That's the baseline of the assumption, because we're arguing hypothetical with the Supreme Court rules that way.
That was a simple yes or no question. He answered it. That's awesome.
Yeah.
Okay, cool. Okay. If that is the case, then I think that what should happen is that it should go first. There should be an actual primary. And if he wins the actual primary, then he actually gets to go to an actual general election, right? And then once there's an actual general election, then it should go to the Congress, surely, right?
So just to be clear, wait a minute.
There's confusion. There's confusion.
Clear it up, Blacktoid.
Okay, I don't disagree with you, Quibbles, that I think Congress, ultimately deciding whether or not he's disqualified is going to be up, assuming that Article 3 applies to the president, which the Supreme Court's also going to decide, hopefully, would be up to Congress. Okay, I don't deny that. But what they're saying is, if the Supreme Court, let's say, comes down with some landmark decision and they say, look, not only is Article 3 self-executing, but when they were referencing offices, they also intended to include the president. Oh, and by the way, Trump did commit insurrection. If they rule all those three things, right, and everything in here, it's all proper, and he's just qualified. If the Supreme Court rules that way, that's it. And I agree. If they rule that way, and you still want to be president, that must mean that he's above the law. There's no way around that, for sure.
I agree. My point is, I don't think that having this be decided, the component of whether or not there's standing of the Supreme Court versus standing of the Congress. I don't think that the standing.
But that's a legal question, right? That's a legal question, not a prudential one. And so, Lactoid could be correct that courts have no say here, that states have no say here, and really, the Supreme Court is not going to be ruling as the federal court. The Supreme Court is going to be ruling whether the state court has authority. So the Supreme Court's going to be answering whether states have the authority to do this. So they're not going to be even answering on the federal side of it. And the Supreme Court could answer in your favor and say it's Congress who needs to pass implementing legislation. That is absolutely a route so that this Supreme Court might take. There's actually a decent chance it does. And I'm not sitting here and saying that that's inconceivable, but that's a legal question. But when people like Wick, love Wick, respect Wick, this is a great panel, and it's so awesome that the main thing happened.
And to be fair, it's a fair question. It's an important question that he's asking.
When he says, couldn't there be discretion on when to apply this? The answer I have to give respectfully is no, right? Is there discretion on whether or not to apply the age requirement of Article 2? No, there's no discretion. Is there discretion on whether or not to have the Second Amendment? No. Is there discretion? Now, there are some parts where the Constitution will give discretion, right? It says you may implement certain legislation or as the Congress may deem necessary. In those situations, you can have discretion if there's an explicit grant of discretion. But in cases where there's not permissive language, but mandatory language. Shall. The president shall be 35, whatever. There's no discretion here. And we follow the Constitution or we don't.
Well, and the other thing I really want to drive home to this, because this is what I was trying to get at earlier with Quibbles, and it could be that I alone have this misunderstanding, and it could be that I hear similar language in so many other contexts, and I hear it even in Wick's very good question, because it's a fair question. The idea that we shouldn't pursue a certain path. And by the way, I'll just remind everybody, because it was said earlier something about Democratic judges or Democrats doing this. It was Republican voters who brought this suit in Colorado, okay? But this idea that we shouldn't do a thing because it will piss certain people off or it's divisive. There's no scenario here that's not going to piss at least 30 to 40% of the country off. Because right now, preliminary polling supports removing Trump from the ballot. A slight majority support kicking Trump, that Colorado did the right thing. So my question is, if that's what holds us up, well, it's divisive. It's potentially divisive. We shouldn't do this. I don't know a non-divisive path forward. Because if the Supreme Court comes down and says Donald Trump is not disqualified, there are going to be a lot of people pissed off. Say the motherfucker tried to steal an election. He incited January 6th or whatever. Teflon Don gets away with it again. So that's why I don't know.
Well,
I
the
think it's an
reason-
important question, but
so-
but
Can
So
I
I think that-
clarify something I said real quick? Just to,
Sure.
so some people are misunderstanding me in my own chat. I don't think that Trump did do insurrection. I think the factual analysis was I disagree with it. I'm just saying if the Supreme Court does find that he did do it, then that is the finding of the Supreme Court, and that is you can't. There's nothing higher that can say, well, no,
Sure.
it didn't. I mean,
Certainly.
it's the Supreme Court.
I understand that, but to kind of address your point there, Josiah, like
Sure.
everything we do is going to be divisive. We can understand that, but we can understand that there is a spectrum here of things, right? Like no matter what happens, yes, there will be a cadre or a cohort who think that yes, democracy was ended and stolen, and Trump should be our supreme leader because he was actually elected in 2020. They believe that sans fact, however. What we don't do, though, is give them ammunition to convince others, because the reason that only a few people believe that, right, is because the evidence doesn't support that. But
May I
once you
ask
start
you-
having, if I may, once you start having situations where you have a court or legislative system overturning the will of the people, then you suddenly, a lot more people think, well, maybe they have a point.
I've got a couple. Fair. Okay, I got a couple of questions for you. So okay. Number one, when it comes to a small cohort, like 70 to 80% of the people, according to consistent polling in the Republican Party, think the 2020 election was stolen, and they have no factual basis for it. It's a fucking cult. Okay, number one. Number two, people are making the same argument, Wick, about pursuing Trump criminally or civilly. It's divisive. How dare he's a political figure. You're attacked. Biden's allowing his political rival to be attacked. You can't prosecute Trump himself is trying to make this case right now that he's entitled to absolute immunity. And so the civil and criminal proceedings should be dropped. And that's where I'm confused. It's like it all ends in one place.
No,
Trump is above the law.
The contexts are different here, right? We can argue whether or not someone who's been criminally convicted can or should be president or not, or moved from office or not, but these are separate questions, right? The questions of whether or not he should be thrown in jail is fundamentally different than should he be allowed to actually run for office. Should someone who is currently serving time in prison be allowed to run for office? Some people would say, sure, if that's the will of the people.
I understand. Real quick, I think we're pondering what Josiah is getting at isn't comparing the criminal sanction and the disqualification as such. What he's saying is the same kind of prudential arguments. That is like, well, he's arguing for absolute immunity. Like, shouldn't we give him this? Should we be going after him? Because if he gets convicted, people are going to be upset. People are going to be angry. People are going to think the election is stolen because it's political interference, because you're trying to convict him in order to hurt him in the polls. Those kind of prudential arguments are applicable both in the disqualification context and the criminal context. And in that way, right, if those were to dominate in either world, the only possible thing you could say is that he's above the law. And I don't think that there's any way to disagree with that.
Can we agree?
Go ahead, John.
I'm sorry. Thank you so much. Can we agree, or is there evidence otherwise, that should the Supreme Court do the list of 3 things that Lactoid laid out? Should the Supreme Court decide that Trump was in charge of an insurrection, et cetera, would it necessitate that we then try him for treason?
No.
No.
Because they're different, right? Like, and the standards are different too. So when I say standard, I mean the proof
the whole
needed
criminally versus right?
Yeah. So like, in a criminal case, there's this proof beyond a reasonable doubt standard, and that will often be the deciding factor about whether or not you are sued civilly for, like, let's say fraud. In the New York trial, they're suing him for civil fraud, not criminal fraud.
But this is, I'm sorry to interrupt you, but this is what you were talking about earlier, where the Constitution is not a criminal code.
Right. So the Constitution, we should think of the Constitution as the structure of our country, and even the Constitution does not criminalize. You can make an argument for it. Does not criminalize treason. It just gives the definition for treason. Some people might say that it does by virtue of defining it, it criminalizes it. But you should think of these as separate things, and that's number one. And number two is treason is different than insurrection or rebellion, and those are different crimes or things that could happen. You could think of a treason as not involving force, or threat of force, which insurrections require, at least under my definition of insurrection, force or threat of force.
So someone could be guilty of insurrection.
Let Johnny finish. Go ahead.
Thank you.
Yeah.
I don't know that I necessarily agree with that, just because I've read several legal definitions of insurrection, and the words especially violent insurrections were used, but not exclusively violent insurrection.
You're correct. There's some definitions of insurrection that are extremely broad and will not make force a necessary part of that definition. They'll say something like a rising. Well, is a rising involving force? It's a good point. But like, that's why when there is any ambiguity, we might read into like, well, what did the framers mean when they use the term insurrection? What were they referring to?
And then we have rebellion
And the First Amendment
mentioned,
protections
etc.
as well.
But there's also something that we really haven't gotten to talk about yet, which I've been happy to have this part of the conversation, by the way, but the idea that something that I put in my initial statements, the idea that Trump either commanded January 6th and wanted it to happen, or that his rebellion, insurrection, etc., was methodized by his intimidation of states to try and overturn their elections, or was it both? That's something that I don't think we as a panel have really discussed.
There's another argument too, which I think is a stronger one, which is that, and again, it doesn't rely solely on his comments before, because I didn't originally think Trump committed an insurrection because I was relying only on his public comments. But what happened when they had the special review of the issue, it was his comments before that incited the protest, and then his, you could say, refusal or dereliction of duty to act against the violent aspects of the protest that he motivated. So you can argue, well, his words motivated a peaceful protest. Sure, but once it became not peaceful, he had unique deference to act against the violent elements of that protest and then didn't.
From as the
one who motivated those people to assemble in the first place, and the one with unique authority to quell the violent aspects of the protest, I think there is a good argument for his at least giving aid to an insurrection, because again, Section 3 has two separate ways that you can engage with an insurrection. You don't have
or
to
give aid
engage
and comfort.
So I don't necessarily think it is wholly convincing. That's why I said that, like, I don't know if it's 100% irrefutable. That's why I said I would like the Supreme Court to lay out exactly what process we need to do in order to, or what process has already been done that shows that he engaged in insurrection. But as long as they do lay out and clarify that process, I would be satisfied with them ruling that he's ineligible to be president, because there is an argument that because he both motivated the assembly and then refused to quell the violence in that assembly, that
something akin to negligence or overly brash.
Yeah, because people compared like Democratic lawmakers from other states, right, raising bail for people in BLM riots, and I thought that was shitty. And I thought state legislators that were telling people to keep doing the BLM riots and shit like that were also shitty. But they weren't giving aid to an insurrection because they weren't also in a unique position to quell the violence in those riots and refusing to do so.
Okay.
They were only doing the first part that is not inciting an insurrection on its own.
So I just want to clarify something. I'm sorry. So Pisco, your proposal is that someone can be guilty of insurrection or rebellion against the Constitution, but not guilty of treason?
Yes. Because think about it. I mean, like, John Scott brought up a good point that there are multiple definitions of insurrection, but whatever one you land on, right? It's clearly different than treason, because the Constitution lays out the definition of treason, and there are specific procedures and particular definitions, a very, very narrow definition of treason that was specified specifically for treason. And so that would seem to imply a difference between the term that was specifically called out and given additional constraints and narrowness, as opposed to the one that was mentioned in Section 3. If they wanted treason to be equivalent to insurrection, surely they would have used the term treason in Section 3. Does that make sense?
Yeah, it does. So I just want to further flesh out. This is coming to Wick's point earlier. about like the impact that this is going to have on like whether or not even we'll have a 28 election, right? After this is all done, you're proposing a situation where not only did potentially the primary already happen, and then the general election is not a real election because the Republican candidate isn't actually eligible to run, and so therefore, even though they're on the ballot potentially, they're not an actual candidate. So it's actually just an election between like allegedly the Libertarian and realistically Biden, and that's one option. And then also on top of that, you're also jointly saying that you could potentially have a very high case, everyone's watching it type of case of whether or not he's guilty of treason, and he could be found innocent of treason. Trump could be found innocent of treason jointly to all of this going on.
I don't think treason applies to Trump's conduct. At least I haven't thought about the legal standard. Treason usually involves references to foreign powers and essentially being a traitor with respect to foreign powers. And so I don't know that I can fulfill any of what Trump did there.
Yeah, treason against the United States shall consist only of in levying war against them or in adhering to their enemies, that may in comfort. So you're saying that this is not treason, even though you also think that potentially it was an attempted rebellion, which
I think it was an insurrection
versus a.
It was a coup attempt for sure. It was a coup attempt, and Trump tried to commit a coup.
Isn't that trying to levy war against the United States?
No, I don't think necessarily. You can have bloodless coups. You can have coups that are now. When I say coup, I'm kind of using it in a little bit of a reckless manner. There's actually a disagreement in the literature on coups about what the proper definition of coup is. There's two scholars, Powell and Thine, who have a running, I know all about this because I have arguments about coups, have a running list of the kind of coups, and they don't consider Trump's January 6th to be a coup attempt. So there's actually disagreement on the literature about what constitutes a coup attempt. So I'm kind of giving you my personal opinion based on what the definition I agree with.
I have a question as well that directly relates to that, actually. And it's something that I've wanted to ask since before the panel started. Is in the case that Trump genuinely believed that, and I don't know that he did, I think that he was intimidating these people and he just wanted to be president again.
Yep.
In the case that he genuinely believed that he was trying to right a wrongful election and not usurp the power of the United States, but restore the power of the United States, how would that affect?
It's a great question because it fits our intuitions about, like, let's say he was right? What if Trump was right about everything, right?
Exactly.
And I don't say that's even like in the realm of physics impossible, right? It could all just be, right? Maybe 0.001% chance that it was all a conspiracy. I'm not here to say that it's physically impossible for that to be true.
Flip that.
But what's that? Clip it, right? The response to that is, though, there is no good faith exception to insurrection or rebellion. The rebels, the Confederates, genuinely thought that they had the right to secede. The rebels thought they genuinely had a right to their slaves as property. They were genuine, right? These were all legal theories they had prepared. They argued it in front of their delegates when they voted on the secession resolutions. And so they were very genuine in their belief that what was happening was legal, and the secession not only was legal, but was justified, and a restoration of the proper way that the country should be ran. And so the answer to the question is, like, there's no good faith exception there. Trump could think that the election is stolen.
Yeah.
Well, I was going to say, so Trump's own former Attorney General Bill Barr was asked this point blank, and he said he's not going to comment on Trump's mental state, presumably because he's going to be a witness at some point in one of the trials. But he said Trump's intent is immaterial to him, and this is a guy who was Trump's top law enforcement officer. He said, and this is the example he offered, he said, "You may think the bank is unlawfully holding your finances or your money. You do not have a right to rob the bank, and no judge would ever agree that you did." So whether or not Trump, who is, of course, a malignant narcissist and a moron and inferior in all ways to Biden, it doesn't matter whether he thought that the 2020 election was stolen. It doesn't give him permission to try to steal a perfectly free and fair election.
You know what does give us permission? The fact that we're kind of coming up on the 2-hour mark here. So if you forgive me, I do have to make some money. And I'm going to read some of the super chats that I've been getting. Thank you for your generous donations, by the way. Gang, if you've been liking this content, please hit that like button, hit that subscribe button. If you're watching this on Twitch or on Kick, give me a follow, give some subs, bits, super chats, and I'll read them out. So I'm going to go through them as quickly as I possibly can. I got a few. So here we go. $5 or $10, I'm sorry, from Artemis Fowl. I like how the only person who actually did any research on the topic is getting told he has no idea what he's talking about. Why aren't any of the other guests bringing up court cases? $5 from the same individual. Pisco. Yes,
Yeah.
I have case law that agrees with me. Proceeds not to show any of the cases. $5 also from Artemis Fowl. Does Pisco now support every Secretary of State in red states removing Biden for the ballot unilaterally, so long as the state law doesn't forbid it? And also from Artemis Fowl, $5. Gotcha. So whenever the Democrats threaten the eligibility of a candidate, even little, this Republican is going to immediately give up on them. That's Jeptan. $5 from Kilo the Giant. Who on the
Wait,
panel?
I'm sorry. Can we answer some of these?
Wait, you said
Yeah,
that
you
one
gotta
was
go
for
through
me.
them.
I
This
wasn't
is from-
listening.
He wants to go through, but I'll answer all the ones that directed me.
Yeah.
Yeah,
I will give you a chance. But there's
can
a
you
few.
Repeat
So-
the one that was to
Yeah,
me.
yeah.
The one that was to you was gotcha. So whenever the Democrats threaten the eligibility of a candidate even little, this Republican is going to immediately give up on them.
Okay.
$5 from
I'll
Kilo the
reply
Giant to ask who on the panel believes that a Supreme Court would hypothetically uphold the disqualification. We already asked that. $20 from Artemis Fowl. So let's take stock here. Who here thinks that they're the good guys when they need to water down definitions and find extreme edge cases and novel interpretations in order to remove their political opponents from office? $5, to be clear, other than Trump telling people to be peaceful and then go home, which he did, what else did he have the power to do? And then $10
What?
finally.
Wait, who said that? Who said that one
That
again?
was
I'm sorry, I
Artemis
want to
Fowl.
make note of that.
Oh
my God.
$10.
Same person, yeah.
National Guard and additional police presence was refused by Pelosi and Mayor Bowser due to the park tear gas incident. Where
I'm
Antifa
taking
tried
that
to
one,
burn
Pisco.
down
You can
St.
take the
John's
other ones. I'm
Church.
taking that one.
But let's give Pisco. He was addressed a lot. Let's give him a chance. And then
Don't address the DC one. I
Yeah,
can't.
yeah,
I
we'll
can't-
go to Jeff
won't
Dan,
do that. I
then we'll
mean,
go to-
so there's the argument about the parade of horribles that if you bring up the fact of insurrection and you apply Section 3, won't all your political enemies start to try to apply it? Let them try. And the other alternative, that's an argument that proves too much, is to never apply Section 3 because we're worried about that ratchet. I trust our system and our courts to apply the law judiciously and to look at the facts and to apply the definitions like we do in every other case. Like we trust them to apply other issues of great importance in this country, having to do with individual rights, having to do with whether or not laws should be struck down. The courts are plenty competent to hear those cases, or the Congress, if it comes to Congress to consider it. And so, yeah, I accept that one of the results of this litigation might be that additional challenges are brought, but guess what? Section 3 is what it is, and you can't just use that as an argument to defeat enforcement at all times. There was another thing that was said, which was stretching definitions and diluting them. Listen, any definition of insurrection needs to include the Whiskey Rebellion, which was a known insurrection at the time, and a prominent insurrection, the most famous use of federal authority after the Constitution was passed to show that the new Constitution was vigorous was for George Washington to go on the field and put down this insurrection. How many people died in that? 3 people died in that insurrection. Most of them just left as soon as the federal troops were rallied, and it wasn't even trying to take over the country. It was revolts and trying to undermine the law with respect to tax impositions and people who are trying to collect taxes. So the standard for insurrection needs to include both the Civil War, which was worse than January 6th, obviously, and it needs to include Whiskey Rebellion. It needs to include both because the framers absolutely would have included both.
While we're on you, Pisco, from a different person, $20 from Go Away to ask 2 questions. How likely are the Republicans to use this in a bad faith to attempt to subvert?
Extremely likely. They're already doing it. I mean, I don't deny that, but it's not going to be successful because in this country we still have rule of law.
Sure.
And if you apply the standards to the facts, you're just not going to be able to make out that Joe Biden engaged in insurrection and rebellion with respect to BLM. No matter how much you want to stretch these words, they're not going to include that kind of conduct.
Pisco, show how good faith you are by telling them, as you told before,
but
with respect to BLM.
If Biden endorsed rioting, right, and encouraged people specifically to do rioting and to like attack federal courthouses, or if Biden was like supporting what the Chaz people were doing, that absolutely would be engaging in insurrection or rebellion. Are you kidding? Chaz is like trying to become an independent zone in the middle of a state. How could that not be an insurrection? How could BLM rioters attacking federal courthouses not be an insurrection? If like attacking tax collectors and having a joint plan to obstruct the enforcement of the tax code, as defined in the rum tax or whatever the tax was at the time, is an insurrection. Clearly, the BLM attacks on federal courthouses for reasons of political disagreement on racial policy, that would also qualify as an insurrection. There's no double standard here. It's about who engaged.
How are you defining supporting?
Engaged in is and also give aid or comfort. But engaged in, if you read the Colorado Supreme Court opinion, requires a volitional, intentional act in support, right? It doesn't, just agreeing with something isn't engaging in it. Just voicing some support isn't engaging in it. It has to rise to a level, like, let's say you were like selling arms to the people in Chaz zone. That would be engaging in insurrection, right?
Trump didn't do that, right?
No, he didn't.
No, but he's giving an example.
Trump's actions.
Obviously, that would be an example.
Trump,
of course.
but that's what I was saying earlier. Trump was in the unique position to quell the violent aspects of the January 6th riots.
And the
He
response to
incited.
that
So
is
what the court
interesting.
determined was incitement.
Yeah.
Take it piece by piece.
I
Jeb,
hate
what you just said
fucking
there is
determination.
incorrect. Because what you just said there was that he lacked to do an action. Failure to do an action is not itself an action.
No, but that's
dereliction of duty is an
Failure
action.
to stop something isn't
So
insurrection.
the Colorado Supreme Court stopped short. The Colorado Supreme Court stopped short of applying affirmative duties, but absent some kind of actual affirmative duty that you're self-imposing on yourself, like taking the oath of office. But what Jeb Tan is referencing is relevant even absent an affirmative duty, because it speaks to Trump's intent, and you need intent to get to incitement. So incitement is what the court alleged him to have done by engaging.
So he has to intend to overthrow the election.
No. He has to intend for. He needs to intend. He needs to intend for either unlawful activity to occur or for violence to occur. That's part of the Brandenburg standard. It needs intent. And so what Jeb is pointing to is actually very relevant, because it's almost like an adoptive admission. Suppose that like you were on trial for murder, and it was, have you guys ever seen those like JCS videos where like someone who's accused of, have you seen, you know who Chris Watts murder is? The Chris Watts murder, where like something is brought to his attention, like, hey, isn't this weird that like, you know, you're pulling out of your truck the same night that your family's dead or some shit like that? And he's like, huh, that is weird. Now that all occurred after the actual insurrection started, or the actual murders took place, but it speaks to his intent, right? If there's some actions that are inconsistent with what we would think someone, what's that?
Can we list what Trump's intent would have to be in order for it to be insurrection?
He needs to intend an imminent unlawful activity or imminent violence.
Yeah.
It's
so I
imminent.
get what you're saying.
Unlawful
You're saying, does
activity.
he need to intend for the government to be overthrown, which is a little bit more
No,
of a
that's not what I
likelihood of
That's not what I
that's I mean verbatim. You
That's
said
not at
does
all
he
what I
need
said.
to?
You did
Yeah,
say
I-
that.
Hold on.
Yeah,
You're both
you said
here.
that he
It was
needs
the
to-
government-
Stop.
no, no,
Stop.
no, no,
Stop. Oh my God.
rebellion,
Stop.
yes.
Both of you. Stop for a minute. Like, we don't need to guess what each others are saying. We can simply ask them. Quibbles, what is it that you were saying?
I'm saying for rebellion, yes, overthrowing is necessary as a goal to be an intent to in the case of rebellion. In the case of insurrection, that's not the same as rebellion.
Wait, are you sure
okay?
about that? Rebellion is you need to have the overthrowing intent there?
Yeah,
I mean, have you run the analysis? I mean, there are rebellions. So just so you know, the Whiskey Rebellion is known as a Whiskey Rebellion, and there was no greater plan there to overturn the United States
Weren't they trying
government.
to overthrow the ability of it to impose a
Right, but
tax?
that's kind of like a lesser obstruct the government, like a lawful government purpose. You know, but I'm just saying, I agree with you that rebellion has a greater purpose usually implied in that thing, but I just haven't run the analysis the same as insurrection. So just don't be too quick to apply your own labels there. There's a big legal analysis about what these terms mean. And I'm sure that Lactoid disagrees with me on what insurrection is.
How are you?
Well, I
parsing
disagree with you that
rebellion?
this was insurrection.
Right,
First of all,
there.
so I mean, I'm
That's a
hoping
broader
we
question,
can-
but I just want to first understand what he means when he says insurrection.
Okay,
So I
finish
wanna- I wanna-
it first, but
he said what he
Lactoid
means,
hasn't
what he means.
spoken in a while, so.
Yeah. He says what he meant. He says
is imminent unlawful activity or violence.
No, sorry. Don't confuse incitement with insurrection, right? An incitement is an imminent call for lawless action. Or violent action, right? So if I say to you, if I'm right at the courthouse steps and say, everybody charge, go in there and kill the judges, even though no one does something,
Somebody clip
But
that.
Trump's
that's
intent
that's
for it
incitement.
to be insurrection and for him to be guilty of said
You
insurrection.
need to have an
whether or not
intent
January
to bring that about.
It's a two-part. It's got to be an incitement, and then also was it an insurrection? It's like those are two questions.
So there's two parts of this. So there's so you'd have to first understand that it is an insurrection. That'd be the first component of Pisco's decision.
Yes, it has to be an insurrection. You need to have engaged, and in order to, this is how overall operations goes. All right, ready? There's insurrection and engaged in, right? Insurrection is its own thing that we can debate about. What the court found was in one way that you can engage is to incite, and so if they have to prove he incited to prove he engaged, and they have to prove that he engaged in an insurrection.
Okay,
Yes.
so the
But it's not
I
just
think that's fair.
engagement, is it? It's not just engagement, is
incitement
it?
here
It's
would
also
Give aid
aiding
or comfort.
or
Yeah,
comfort,
But that
which would
wasn't
also, I
briefed.
think,
That's not an issue because it wasn't briefed and no one argued it. So
I
it's
see.
not part
They
of the
found
case.
that he engaged in it because, again, it's sort of a two-part thing.
Because of the incitement.
Yeah, because
They
of the
allege.
incitement, because and the intent was shown by a couple things. One, right, him saying things like "stop the count, fight like hell," things like that. Stop the count being worse than fight like hell from a legal perspective, because that is him giving
Potentially,
direct intent to stop a process that, if stopped, would have violated like state and federal law.
100%.
And then the confirming his intent was him failing to act against the people that were doing that and actually stopping the
It's
process.
like an adoptive admission, like someone we would
Yeah.
expect. It's circumstantial evidence of intent, which is the only thing we can do, other sort of like him admitting that, I really wanted something unlawful to happen. We go through.
I want to stick with the stop.
Hold on, but Josiah had a question that he wanted to answer.
We got a lot of people
And I
that
had
want
a
to
point.
talk, that want to think. We are
that's fair.
again
Go
winding
for it,
down,
sorry.
so I want to be as brief as possible.
And I
here.
want to answer the one that was addressed to me. Too.
Yeah,
So
everyone's gonna get a chance. Everyone's gonna get a chance. Lactoid's gonna go, and then we're gonna have Josiah, and then we're gonna have 𝕵𝖎, and then we're gonna close this out.
I love this panel, by the way. Great work,
Well,
Wick.
thank you.
Yeah, it's been
I
fun.
try to
It's
put
been
on
very
a good
interesting.
show.
No, I do. I like it as well, and I would like to talk about whether or not the Article 3 under officers, if the president's included, I would like to talk about that.
That's a great thing to end on. Yeah.
Yeah, it'd be a great thing to end
all
on.
of which Trump's
but-
panels need to be split up into like 7 different subsections. Man.
Like I just don't have
So-
12 hours in a day, gang. So we gotta.
So, but on this specific topic, so 𝕵𝖎, I understand that you've come to this conclusion that an insurrection did occur. That Trump incited the insurrection. I guess this part's difficult because it's not a legal question; it's a fact question, right? And I think that, well, first of all, it's particularly dangerous now if we set up the standard where lower court, district courts can, because they're in the best position to evaluate the facts, they'll be able to evaluate facts, which then have a deference to them, and then they could, in bad faith, apply those facts to law, where the later court might say, well, yeah, like obviously the law is this, even if the facts aren't this, right? So when you're going through the district court decision and the Supreme Court decision, I understand you've referenced a couple of things that, obviously arguments that indicate that Trump engaged in insurrection. But I mean, to some extent, this is going to be just like is this convincing or not convincing? But when I look at the evidence, like when I'm looking at what they're laying out, it absolutely does seem like they're super emphasizing like a fight like hell, for example. They emphasize the fact that he didn't condemn the mob after he told them to go home, which I don't actually think, I don't think those things are relevant, particularly to whether or not he had the intent for insurrection. Really? So for me, I think the critical element is, so the timeline that they established was, first of all, anything prior January 6th, when he's saying stop the steal or whatever, I think that's all First Amendment, right? He's not actually saying go fucking.
Wait a second, Lactoid. There can be a lot of things that are protected speech.
I know. Not only the protected speech, but I think it's like it's not actually related. It could potentially explain a motivation, I suppose, but I don't think that like in of itself, him saying the election was stolen is imperative to whether or not he called for an insurrection. I think the only question of whether or not he called for an insurrection are the statements to the mob on that day, right? Did he tell the mob to go commit violence? Well, I don't think that he did. I think that when the only indication that they allege, by the way, because they're pulling stuff from the January 6th committee, they're not actually pulling shit from discovery, which wasn't actually even allowed in this fucking trial, right?
Of course it was.
There was no discovery, right?
There wasn't traditional extensive discovery, but it's because it's an election case.
Sure, you're right. I understand. So they pulled shit from the January 6th committee, and
they also had live witnesses and expert testimony.
Well, I understand. I know the expert testimony. I think that's a little bit political as well. I think the January 6th testimony, I watched that. I thought that was the whole political circus. I understand that the allegation is that Trump knew about that there was violence occurring at the Capitol at around 1:30, and that at around 2:14 or around 45 an hour later, around that time, he tweeted to be peaceful, to stay peaceful. I think that's critical, right? Now, what the expert in, I guess, extremism that they brought forward said is that, well, actually, when he said be peaceful to his audience knew that the violent elements of his audience knew that he wasn't actually being serious about that, but he was just trying to create plausible deniability. That was the sort of argument that they're putting forward. But do you at least, Jeb10, can you at least agree with me, though, that it's very well possible, and I would argue probable, that when he said stay peaceful, he meant it because, remember, this was coming from the law and order president who had campaigned for the support of police and law enforcement for how fucking long, and had just gotten done condemning BLM for attacking cops. And of course he didn't want the fucking rioters to attack cops or the insurrectionists to attack cops. Of course he had no intention of doing that.
Why didn't he call them off?
So he told them to stay peaceful. I think
they weren't peaceful.
They weren't peaceful at the time he tweeted it.
I think he wanted the peaceful protesters, which, if we're going to be realistic, most people did not participate in the violence. So technically it was a mostly peaceful protest. I think he wanted the peaceful protest element to remain, right? Obviously, because he thought the election was stolen.
He could have said that.
He absolutely ordered people to be peaceful and to not attack law enforcement, and even said that in his speech prior. They are the courts here are minimizing those statements, I think unjustly, to kind of put forward this theory of, well, we don't think he actually meant it. We think that he was telegraphing to the white nationalists and the Proud Boys that in reality he was trying to get people attacked. I don't think that's the case. What I think happened is that he didn't think it was as nearly as big of a deal as people within that first hour, or basically until he said stay peaceful. He heard more reports saying it was an issue, so then he told them to stay peaceful. And then when shit really started getting out of hand, he told them to go home.
Yeah, no, so the question you asked directly to me, I can agree it's possible, maybe even probable. He didn't want them to attack law enforcement. My issue is the attacking law enforcement isn't the most insurrectionist element of that assembly that I would address. The one that I would say is the most insurrection-y is the getting into the building so that the count would be stopped, because that's a legal process for the peaceful transfer of power that they're trying to interrupt through physical presence in the Capitol.
And he'd have to go through cops to do that, though.
So that's where I say his intent was kind of shown by words he said before, because he did do the stop the steal and specifically stop the count rhetoric so much. Even if he didn't say it on the day, he had established that as the narrative and as the goal, stop the count thoroughly. That
what do you mean by that? He was talking to the representatives when he was saying
everyone understood. Ask the people at the ground what they thought.
But then
I don't disagree. People can misinterpret things, but when you're looking at his statements, I'm not saying don't say come on. When you look at when you look at who his base is, law enforcement, when you see that he's against riots so far, when you see that he's telling people to stay peaceful,
why didn't he call him off? You have no answer to that. Why didn't he call him off?
When you tell the violent elements to be peaceful, this is calling it off.
No, he said to stay peaceful. They weren't peaceful. They were not peaceful at all. He said stay peaceful.
Stay peaceful.
And by the way, he only issued that tweet after Ivanka marched into his office. So this fucking idea that he was trying to volunteer. This idea that he was just proactively that he was proactively wanting to encourage people to be peaceful is just not true, Lactoid. And by the way, if we're also looking at Trump's history, because you say, listen, he clearly didn't support the violence because he opposed BLM protests. Trump's political career is littered with violent rhetoric. Why don't you fucking accommodate for that? This idea that he was some angel, this pacifistic angel.
No, yeah. So here's my thing. Though.
Never against cops.
So what you're saying?
Are
So wait a minute.
prosecutors cops in your book?
And he condemned, by the way, the bunch of shit that BLM did, which I think Pisco, under the definitions you provided, like burning down police precincts.
I already said those are a lot of those insurrections.
Yeah, I'm not coming at you. I think a lot of that stuff was insurrections, right? And he was out there speaking against it. He was saying this is fucking crazy. Like, you should not be
They
doing
were
this.
anti-Trump, not because he's against all insurrections. Come on, it's absurd.
Well, no, they were anti-law enforcement, right? Primarily, and his base is law enforcement.
I don't think
they're his political
he
enemies.
directly wanted them to attack law enforcement. I agree, even on something that Josiah and Pisco won't agree with, which is that his words beforehand and even his words during the tweet that you're mentioning and everything else, I don't think he could be considered having engaged in an insurrection solely off of those. My issue is being in a unique position to stop them and not doing it, and only tweeting and not doing anything else showed his intent was at least that he wanted them to interrupt the peaceful transfer of power, which to me is the insurrectionist element in that.
So he said his
hang on, big enough of a deal.
Folks,
right?
Failing to stop something isn't the same as doing something.
Words are always in context, is how we understand them, right? You can say anything you want in a vacuum. I think there was a little bit of like, well, we should only consider the actual words he said in the second third state. So in context, right? Let's talk about the peaceful. Self-serving statements of peacefulness.
Briefly, and then we do have to move on.
Okay. Peaceful and patriotically, that was said an hour before Fight Like Hell in his speech. And why didn't he reiterate it right at the end? Why, if he is committed to well, hang on.
Why did he say it again?
So in your guys' world, all it takes for you to not be guilty of incitement is you could say at the start of your speech, "Hey, everyone be peaceful," and then for the next 3 hours or unlimited time, you could say, "You all need to go inside there and kill everybody."
He didn't say that. That's not what he did.
He didn't say that.
Hang on a second.
He said, "Stop the count and fight like hell."
Hang on a second.
Neither of those are military by definition.
Pisco's wanting to find. Pisco's wanting to know about how much plausible deniability applies.
This is a hypothetical. This is a hypothetical to show you.
Okay, cool. That would be insurrection. If that was what he did, obviously that would be insurrection. There would be no question.
Okay, so then we agree that self-serving statements to the contrary does not decide the issue about whether or not something is or is not incitement. And in context, we all understand that the point of the rally there was to stop the steal. That was the purpose of it. And when Trump uses that language, fight like hell, you can't fight with your arms behind your back.
He didn't say that during
He did
the
say
speech,
that.
though.
No, he did say no.
I watched the speech today and took notes on it. Everything that he said during that hour and 13-minute speech that was a direct command was not toward the crowd, but toward elected officials.
That's not true.
What is
that's
the
not
quote?
true.
We fight like hell.
No,
and
so
if you
that's
don't fight
no,
like
but
hell,
that's
you're not going to have a country anymore.
Well, no, and
You could
Quibbles,
knock us down easily if you simply gave us a quote where he did that.
Quibbles, this is what I'm trying to.
I just
gave a quote. First of all,
I just gave it to you. I'll say it again. Stop talking, Quibbles.
Wait, stop.
It is
Just
we
say it.
fight
Okay.
like hell, and if you don't fight like hell, you're not going to have a country anymore. That's the quote.
Wait, I'm
that
sorry.
was talking about.
Fight like hell
Sure,
means
so,
fight
yes.
police officers?
Wait,
No, so
technically it is a command, but obviously it's not a call to violence. Obviously.
And here's the
Of
issue.
course, it's not a call to violence.
Quibbles. This is what I was
Bernie
talking about
Sanders
before.
says fight like hell in every single
I'm just
rally.
going to say stay
Engaged
peaceful
in
is obviously
insurrection.
plausible
Okay,
deniability.
okay,
I'm
I'm
gonna say
throwing the flag
that,
on flag. I'm throwing the flag on
universal
flag.
healthcare?
Throwing the flag on flag.
Okay, he's throwing the flag.
I'm throwing the flag on flag because we
You got to actually get some laundry, dude.
we have to get
Yellow towel.
we have to get places, right? I do have to have like a flag, one of those yellow flags. I wanted to give a chance because I know Josiah wanted to respond to that super chat, and I wanted to give him a chance to do so. But then we're going to go into closing statements.
Wait, and me too. There was one addressed directly to me.
Yes,
I'll be
there was
super quick,
one.
Jeb.
I'll
be
give you
super
both
quick.
a chance.
Okay,
since
cool.
you were
I'll
called
make
out.
it. I'll make mine my closing statement. I'll
Yes,
do it after.
please.
I'll
do.
share some of my time with Jeb. So real quick, okay. So the idea that Mayor Bowser and the Capitol Police were in a position to thwart Trump. Donald Trump has exclusive authority over the D.C. National Guard. He does not need permission from the mayor of D.C. or for Nancy Pelosi or for anyone. His authority is supreme, and even if when he delegates it to the Secretary of Defense, he does not abdicate his responsibility for national security. The President of the United States is the highest national security official in the United States. He has the highest responsibility to maintain national security. He delegates some powers to other people, but that responsibility stays with him. So during an insurrection in which his fucking cultists are attacking the United States Capitol, he has the authority and the responsibility to make sure law enforcement is dealing with it. Mayor Bowser can say all the fuck he wants or she wants, and Donald Trump still has the authority to override her. She is in no position to thwart him whatsoever. And again, are you shaking your head, Lactoid?
I think
No,
you cracked
it's popping my neck.
Oh, okay. I was about to say. So that
I was
complaint is
so
just
on edge.
irrelevant. Yeah. Yeah. I was like, come at me, bro. Come at me.
I'm
You said
ready.
you weren't going to be aggro, so I would. Okay, so go ahead, Jeb Tad. Sorry.
Yeah, and I'll make this my closing statement too, Wick, because I was actually going to say my response to this as my closing statement. So the super chat I got was, if Dems accuse any Republican, then this Republican is going to give up on them immediately. And no. And this has been a problem, and I'm probably going to do a larger article about this and Trump and Andrew Tate and how they have co-opted the ideals and the broad and robust innate support for the good quality conservative ideals and like attached them to their bullshit and just completely brainwashed people who were for conservative ideals 4 years ago and made them into zombies for whatever bullshit they want to spew. The issue isn't Dems accusing a Republican and me giving up on them. Okay? You can argue that with the impeachments. You can argue that even with the review on January 6th being mostly Democrats. But again, this is the problem I expressed to Quibbles and the problem I think most people have in their logic, not just politically, but everywhere else. You're looking at things too much in a vacuum. The issue isn't that a bunch of Dems were on the review committee for January 6th. The issue is Republicans refused to cooperate with the January 6th review committee and provided no representation for you as a Republican voter in that committee. They chose not to participate, and so you didn't get to participate. And broader, it's not just Democrats that are going against Trump. We've talked about Bill Barr. Bill Barr has proven to be nothing but a consistent, strong fucking legal scholar, prosecutor, defender of the law. He abandoned Trump. Pence was Trump's own VP. He was one of the most conservative parts of Trump's entire administration, the most true conservative part of his entire administration, who was true to his principles in ways that made everybody go after him, in ways that were even unique to him, not just him being attached to Trump and not going to dinner with women because he's married and shit like that, right? The most conservative, principled guy, he left Trump. Bill Barr left Trump. Pence left Trump. Everybody in Trump's cabinet who was conservative left Trump. Everybody who actually stood strong on principles and ideals have said, this dude did what everyone's saying he did. I can't attach myself to this man any longer. The failures of his presidency were a direct result of his inability to stand on principle and his inability to actually represent the people that voted for him and the ideals that they stood for before he came into office. This is the problem, is you guys are just getting fucking played at this point. All of the people who actually stand for the principles that you voted for Donald Trump to perpetuate in law have left his side because he doesn't perpetuate those principles. He doubles back on everything, even the policy ones. He spent more than any Democrat in the history of the fucking world. He passed more gun legislation than Barack Obama.
Could you repeat that for Lactoid, that first part again?
No, I don't think Lactoid necessarily disagrees with all of this.
Never voted for Trump.
I think Lactoid probably has a
not a Trump supporter.
I think Lactoid has. I'm talking to like general Republicans who would ask this dumb fuck of a question because you've been played, dude. Like, the Democrats aren't the ones who just accused Donald Trump. Every single person who stood on any sort of conservative principles in Donald Trump's cabinet have also accused Donald Trump of doing all the same things. You're just not listening.
Okay.
Gang,
Cheers,
before we get into
brother.
the other things, I just want to thank you all for coming tonight. I know we went over time, but it was a robust discussion. There was a lot of back and forth. I really enjoyed it. Gang, we got the new year coming up, and you think this year was good, next year is going to be even better. We got more shows like this on the way. As the race heats up between the Republican and Democratic parties, right? We are going to have more shows like this, more political discussions, more deep dives into things. So if you like this content, tune in. Jeb Tan, where can people find you? And then we're going to give everyone here a chance to please shout yourself out, tell people where they can find you, and give closing thoughts on this. So, 𝕵𝖎, where can people find you?
I don't really stream, just 𝕵𝖎, RIP on Twitter.
Give him a follow, gang. Thanks for being here. Johnny Scarlett, I really appreciate your questions tonight. It really helped me out and helped drive discussion. Thank you for being here. What are your closing thoughts and where can people find you?
Absolutely. Thank you so much. And I think everybody did an amazing job tonight. I learned things tonight that I did not previously know, which is always my goal coming on a panel like this. All right. And you can find me at twitch.tv/Johnny Scarlett. That's got 2 T's at the end. That's really the only weird thing about it, although that is the classical way to spell it. And I'm an educational streamer. Like I said, I stream about politics, but especially philosophy and history. Now, my final thoughts on this, because I wanted to fully form an opinion through those questions, is that should Trump be established to have incited the insurrection, aided it, etc., I believe that the panel has argued overall excellently that the support of the court, it would be, I think, at the court's discretion, whether or not to use precedent that says Trump must be first indicted or convicted of a crime. I think that that is at the court's discretion, ultimately, based on the panel's arguments. However, having watched the full speech, having read all of his tweets from that day, and having to look through between the lines type logic in order to find the places where he may have incited it, I think that it is still probably 55% up in the air for me personally that the court will even find him guilty of inciting the insurrection, because I believe that that should probably be something that is an absolute before they find it correct. Okay? I think the panel has argued several different things about whether or not he was actually guilty of the insurrection, but ultimately none of those things for me were absolutes. A lot of them were between the lines. And the one thing, however, is that he did say, we fight like hell. We fight like hell, otherwise we won't have a country anymore. By the way, if you take that literally, Trump didn't literally fight like hell. He wasn't talking about himself. Okay? But I want to commend everybody once again. Thank you so much. If Trump is found to have incited it, I think that the court would ultimately find him ineligible for office. However, I don't know if they will find him guilty of incitement. Thank you so much.
Well, thank you for being here. Really appreciate you. 𝕵𝖎, I appreciate your passion. I appreciate you coming on and sharing your strong views on the subject with your knowledge of the details of the cases at play. Where can people find you, and what are your closing thoughts?
You can find me at youtube.com/@ponderingpolitics. I really appreciate the invitation. I love talking about this stuff. And I was like, I love bantering with 𝕊𝖘. It is enjoyable. I know he says it's been kind of a rough time for him. I hate that, buddy. I hope you get feeling better soon. As far as my views on the situation, Donald Trump, I am persuaded that Donald Trump engaged in and aided and abetted an insurrection. He doesn't need to be criminally charged or convicted according to the language of the amendment. The amendment was ratified to protect the country from those who betrayed their oaths of office from ever holding public power again. The logic follows that if we would keep insurrectionists from being local dog catchers, we probably wouldn't want to make them or make it possible for them to become the most powerful, important, and dangerous person in the country, aka the president. So of course the presidency applies. As far as the threat or the divisiveness of this situation, there is no good outcome. There is no non-controversial outcome from these proceedings, but that is entirely the fault of, number one, Donald Trump, and number two, the Republican Party, which leads to what 𝕵𝖎 said. The Republicans had every opportunity in the aftermath of January 6th to grow a set of balls and to grow a spine and to impeach and convict the motherfucker and make him ineligible to hold office, and this could have been dealt with and over with, and now we wouldn't be facing these questions. For me, the question is ultimately, is Donald Trump above the law? Is Donald Trump above the Constitution? He is facing consequences in a variety of arenas where this is the case. He and his followers contend he is above the law. He is above the Constitution. This is controversial. You can't do this. This is non-democratic. Also setting aside what 𝕵𝖎𝖎 pointed out earlier, which is that Republicans have been saying for years, since they're usually on the wrong side of popular opinion and majority rule, we're not a democracy, we're a constitutional republic. Well, it's a sword that cuts both ways. If Donald Trump engaged in and aided and abetted an insurrection, then the Constitution says you don't get to make him president, just like you don't get to make a 32-year-old foreign national president either. So appealing to majority rule and the will of the people is irrelevant to me. At the end of the day, the question is Donald Trump above the law or not? And that's what you have to answer for yourselves. Find me at youtube.com/@ponderingpolitics.
Really appreciate you being here. Thank you. Go give him a follow again. Give him a subscribe. Next up, Lactoid. And Lactoid, again, always reliable, always a voice of reason in these things, always someone with facts at hand. I don't always agree with your interpretation of the facts, but be that as it may. Give us your closing thoughts and where can people find you?
Yeah, so I'm Lactoid. You can find me at LactoidTV on Twitch, Twitter, and YouTube. So I'm not in favor of Trump, but I do think a couple things. Determining that he did an insurrection, the way they did it, I think is a little bit Kafka-esque, right? I know you said peaceful. I know you said go home, but really that was all code words. You can imagine some kind of, horrible fantasy stories of nobody believing you as you continue to try to plead your case. I'm not convinced based on the evidence that he engaged in insurrection, but, this is something we didn't get to, unfortunately. So I want to briefly summarize. Even if Trump did commit insurrection, Article 3 does not include the president when it defines officers. Now, this seems a little bit counterintuitive. Some people were saying, well, anybody who would think the opposite must be a moron, right? If it didn't include it. But the reality is, a prior version of the 14th Amendment included the president and vice president directly. Since then, there have been 3 Supreme Court cases that I mentioned that specifically separate officers from the Supreme Court. This is a direct quote from Moet. Unless a person in the service of government therefore holds his place by virtue of an appointment by the president or by one of the courts of justice or heads of departments authorized by law to make such an appointment, he is not, strictly speaking, an officer of the United States. So, I remain unchanged in all of my assertions. Article 3 is not self-executing. Article 3 does not include the president, and Trump did not commit insurrection in the first place. When Obama was challenged in California a while ago, this was also a case, a district court case in California. There was an allegation that Obama was ineligible because apparently he had been born in Kenya. That case was dismissed because of the political questions doctrine. It wasn't right for a district court to look at the facts and come to the conclusion that Obama was actually born in Kenya, because that's not a question for a district court. That said, like I said at the beginning, this whole opinion from the Supreme Court was fairly well written, and I am here for what is usually I don't have a lot of respect for justices that are of the living constitution theory. I would consider mostly to be political hackery. Try to engage in originalism. So good on them. I want to see more of this. I thought this was a decently written decision, and I'm looking forward to SCOTUS's hopeful decision on the merits. And I want to thank everybody here as well for being so good faith and good to talk to. I'll be honest, I thought this was going to be a lot more difficult to have a conversation with you guys on this, but it wasn't. You guys have been very charitable, and I didn't get, I didn't have to fight on obvious shit. So I appreciate it. Thank you.
Oh, well, thank you for being here. You were part of the reason that this went well. So thank you again. Go give him a follow, gang. Pisco, it's your first time on my show, but I thought you did excellent. You were stunning. I would love to have you on again. Tell people where they can find you and give your closing thoughts. Go ahead.
Thanks a lot. 𝕵𝖎𝖎𝖙𝖘𝖍𝖔𝖜 on Twitter. You can follow me there. If you want constant updates on some of the Section 3 stuff, and I'm sure I've already sort of gotten a bunch of pings about the Maine decision, and there is a companion opinion with it, so you can sort of see the reasoning there. So yeah, love this topic, and I think it's important to talk about it. I think fundamentally everyone needs to be in agreement that whatever we think the Constitution means, it should be enforced. And if that means that the political question doctrine applies and we can't hear this in the courts, that's what it means. If that means that states aren't competent to hear those claims, that's what it means. But if it means that states are competent to hear the claims, if it means that the political question doctrine doesn't apply, as I don't think it ever should for some of these qualification decisions, like Neil Gorsuch ruled in the case. Now I'm not remembering the name of the case, but where he was disqualifying someone from a ballot who was not a natural born citizen, then we need to follow it, even if the consequences are problematic for radicalization and political polarization. If we abandon the Constitution, then we abandon the rule of law, and it's just really an admission, a tacit admission, but a clear one, that Trump is above the law. On the actual like meat and potatoes of the issues, a lot of these procedural ones, I think, are very clearly on the side of the petitioners in the Colorado decision and the Colorado Supreme Court. The whether or not the presidency is an office under the United States, and whether or not the president is an officer of the United States, and whether the president takes an oath to support the Constitution, to me, just read the Colorado Supreme Court analysis there, in my opinion, pretty unassailable. You know, Lactoid criticizes people using secret codes or trying to import secret codes with respect to Trump's speech. It's ridiculous if to import that they were trying to make this little distinction in the phrasing of Section 3 based on office under or officer of the United States, and that kind of minutia difference, when we're really trying to read the Constitution as a public-facing document that's going to be read by ordinary people. And unless there is a reason to take a super highly technical meaning of a term, I don't think that there's any compelling a compelling analysis that leads to that conclusion, as well as multiple times in the founding documents, in the Federalist Papers, referring to presidents as officers of the United States. The people, contemporaneously referring to presidents as officers of the United States during the passages of Section 3, and just the kind of horrible ramifications of making presidents not officers of the United States with respect to other provisions of the Constitution that are key to officers of the United States, and certainly places in the law, statutory law, where officer of the United States is relevant. On the merits questions related to states hearing the cases and courts hearing the cases, this is obviously fit for judicial judicial standards. It's not an unworkable thing for courts to apply terms like insurrection and rebellion. We trust courts to apply criminal statutes. This is not a criminal statute, but that carry come out similar meanings. Like we would never doubt a court's ability to weigh whether or not something is insurrection or rebellion for purposes of a criminal statute. So why should we doubt the competency of courts to hear this case? And why should we doubt the competency of states to hear cases regarding qualifications of candidates? I mean, states are assumed to be the ones who are electing or appointing electors in the first place. They're the ones who are tasked with running these elections and running these systems in the first place. And so states are competent. And every other part of the 14th Amendment is self-executing in that way. On the actual merits, which is the insurrection question, no one can deny that January 6th is an insurrection. And I think that if you look at all the context of Trump's statements, he knew well in advance what his intent was, and on the day in question, what they wanted to do. They wanted to do something unlawful. They wanted to take your vote away from you. They wanted to stop the steal and stop the count. And the way they were going to use that, after Pence denied the ridiculous legal theories of John Eastman and others, was through force or threat of force. Trump knew that this crowd was no threat to him, but he sicked them upon the Congress. And you can try to make out all these little self-serving statements that they immunize him from liability. We know what he meant, and the fact that he did not act afterwards only speaks more about his intent. He did not act expeditiously afterwards. And so I think it's pretty cut and dry. I'm interested to hear what the Supreme Court says on the issue. I out of everything, I think I want some standards from the Supreme Court. I think that's really, really important. I don't think that it's exceedingly likely they're going to affirm the case because of where I think the court's at, just both doctrinally and in terms of personnel. That said, I don't think it's impossible either. And anyone who's has a super high confidence either direction, like someone who's saying 8-1, I don't think that's going to be true. But I think people who are it's going to be 9-0 reversing, I don't think that's going to be true either. But great
7-2.
Panel.
I'll give you 7-2.
Yeah.
Sure. Loved having it, and I'll be if I'm invited, I'll be on again.
I'll hit you up. Last but certainly not least, someone who was rather last minute, but Quibbles, I think you did an excellent job. I think the points you raised were very applicable to the situation, and I echo a lot of your sentiments. I'm sorry, words escape my brain. It's
really
late,
fine, no worries.
okay?
So yeah,
go ahead.
so I'm Quibbles at QuibblesC on Twitter, also at QuibblesC on YouTube. So my thinking about this is a couple of things. The first is the impact on precedent. We didn't really get much pushback from my side of it, which is that the impact on precedent here would be pretty horrible in terms of the impact on the 28 election and elections going forward, and the trust in the institution of our democracy, again, lowercase d democracy. And I understand we're a republic, there are complexities there, but broadly, that is an undergirding thing. I think Pisco made a really interesting point there in his closing statements there, which is that the Constitution is a public-facing document. And when we talk about it as a public-facing document, it needs to be something that can be easily understood by laymen, right? And I think it's interesting that we had this conversation between two lawyers and the rest of us are laymen, right? In that there's a distinction in the way that lawyers look at stuff and the way that the rest of us look at stuff. And when we're talking about that public-facing component, earlier in this conversation, there was also a question of whether or not to engage in insurrection and rebellion is an example of treason. I think that if you asked the overwhelming majority of people in the United States of America whether engaging in insurrection or rebellion was an example of treason, the obvious answer the vast majority of American people would say is, of course it is, right? And so it seems strange to me that when you're talking about it as a public-facing document, you wouldn't recognize that in the facet of the way that the public would understand it. And so that's my broad concern about the way that you're interpreting the Constitution. That I just don't think that you're seeing it in the way that the public would. In addition to that, I also wanted to just sort of jump back a little bit before we close to Josiah's point earlier in terms of this question of whether or not this failure to stop violent or unlawful act is itself unlawful. I don't think that the failure to stop it is the same as to engage in it yourself. I think about the implications that would have on something like, the 16th Street Baptist Church bombing of 1963. I think about the implications that would have on, the police brutality issues, or on a whole host of different things that a bunch of different presidents have failed to stop, or have failed to fight back against with the degree of speed that I might hope that they would. But the failure to act as quickly as you possibly could to stop something is different than to be responsible for inciting it. And so if you're talking about the inciting component as a separate thing than the failure to stop it, I think it's valid. And if you're talking about the incitement component, then there gets to this question of the matter of, stop the count specifically as a statement and fight like hell as specifically as a statement. The fight like hell specific statement, I think, is just, an absurd idea that would be an example of insurrection, because fight like hell is something that basically every single person who is involved in politics at any serious level says to their people in a non-military capacity all the time. Certainly Bernie Sanders has said that. Certainly Hillary Clinton has said that. Certainly Biden has said that. And so that one is I think, very clearly silly. On the stop the count component also, the precedent of the way that he had been saying that for weeks at that point was something that was very clearly pointed at members of elected officials, and specifically jumping back to what Johnny Scarlett was saying, like that is something that very clearly he was talking to officials when he said that in the case of that particular speech. But anyway, it was lovely to talk to you all.
Thank you again for coming. Remember, if you like the stream, hit that like, hit that subscribe button. We're going to rate out Lactoid. You're streaming right now, correct?
Yeah, but not for too much longer.
Oh, not for too much, then we'll go to somewhere else. Is anyone else on here currently streaming?
Johnny Scarlett's streaming, right?
Are you planning to
continue? I am streaming. Yeah, I was going to continue if you guys wanted to talk more. Yeah.
Sure. I'll rate out and do. Let me make sure I get your name spelled right, though. Hold on.
Yeah.
And no stream tomorrow, gang. The next stream it's gonna be on Tuesday. I'm not streaming on New Year's Day. So Tuesday it'll be a call-in show, and then we'll have a full slate for you the week following. So yeah. Make sure you spam those emotes if you got it, and we'll see you guys Tuesday.
Thanks a lot, folks.
Bye.
Thanks.
Bye, everyone.
Have a good one.
Bye.
Quibbles,
welcome!
to clarify, Quibbles, I wasn't, again, my argument is not that his inability to act